to the Spanish team or vice versa really fast, because if we speak fast, then we also tend to omit some information, which is really crucial. Yes, next, please, if anyone is going to speak, please use the microphone, because if you don't use the microphone, then we don't get you down there in that box. Thirdly, let's try omit jargons or abbreviations wherever possible. Yes. And let's also try to be as audible enough as possible. I think that's all. The facilitator has already talked about the 2 channels, English for channel 1 and Spanish for channel 2. I think that's all. Otherwise, if anyone has any problem with the translation equipment, feel free to raise up your left hand, because I think right hand is being used for communication and suggestions, compliments, and or otherwise. Once again, thank you very much. I hope we have a beautiful Baraza.
Thank you very much, Dr. Kayemba. Now, we have an online audience, people that are joining us online. You are welcome. We live in a digital world. And in that digital world, it means we can't afford not to spread the fires out there. So we are going to make sure that we use our hashtag. And I know some of you are just like me. I love pictures. So those of you that love pictures, we have a photo booth outside on the left. Please feel free at any time to go and take your pictures at that booth, because it's about documenting our journeys and documenting such a noble process of us having a South-to-South exchange. And then the comms team, are we aware about the hashtags that are going to be used today? Okay, we have hashtags. Please share and retweet, reshare. Let us have the fire go out there, because it's just about how we build progressive social movements. We can't light a candle and put it under a table. Then lastly, we have an online audience. They're going to share with us their views, and we will collect them and make sure that they are part of this physical, because this Baraza is a hybrid Baraza. Many people are joining us virtually. So with that, without much ado, I'd like to invite the panel that is going to help us set the stage. I'd like to invite Professor Ben Twinomugisha, a professor of law at Makerere University and the chairperson of the Board of Trustees of Haki. Professor Ben, you are welcome, and take your seat. Next, I'd like to invite Madame Mebo Nimwesiga, the acting executive officer, chief executive officer of the Uganda Law Society. Then I'll also invite Dr. Herbert Luswata, the president of the Uganda Medical Association. Next, I'll invite Honorable Madoff Zakaria Mwandenga, the Commissioner of the African Commission on Human and People's Rights, and the chairperson of the Working Group on Economic, Social, and Cultural Rights. Then next, I'll invite our host, Dr. Moses Mulumba, who is going to give us the opening remarks. Please join the opening panel. You are welcome. How can we welcome you to your own event? You are welcome. Hey, we are not clapping. Can you imagine? You know, we are confused. We do not know whether we can welcome the host. Okay, so now we're going to have the opening panel for us to set the wheels in motion, to know why we're here. And of course, we're going to begin with Professor Ben, and then move on to the Uganda Law Society and the Medical Association, and then end with Commissioner Maddock, and finally the opening remarks. You can come here. Professor, we need to see you.
Good morning. Those who were here yesterday, we have already interacted. Those who came today, we shall get to know each other as we move on. I'm Ben Twinomugisha, as I've been introduced. I teach law at Makerere University, and I'm here to learn. Just a simple omission I've seen here, Dr. Murumba, which I told people here. We are sorry, the ones who were making the form there, they just put gender. So if you are neither female or male, we apologize. I don't know what happened because we always have other. So we are sorry about that. If you don't identify with either female or male, there should be a place where you should have done that. We are sorry about that. Okay? So as I said, you are welcome here to this litigation Baraza. Afya na Haki, or Haki, we exist to generate knowledge, enhance advocacy capacities in health, human rights, and sexual reproductive health and rights, which you may even call reproductive justice. We're asked by the translators to go slow. So we employ an Afrocentric approach that embraces positive African narratives and engages African sub-regional institutions and the regional institutions. We support and collaborate with African non-government organizations and engage Africans on African perspectives. It took us some time to debate the question of Afrocentrism, building on works by Afrocentric scholars like Asante, Diop, Nabudere, and others, to inquire into, for example, the history and origin of most of the sexual and reproductive health rights concepts we have, and see how we can either decolonize our attitudes towards our understanding of those concepts or come up with new concepts. So Haki launched the LIRA program to produce reproductive justice in Africa. To promote reproductive justice in Africa through evidence-based litigation for sexual and reproductive health and rights access. I could say that Haki, built on earlier work by the other organization which I chair, Center for Health, Human Rights and Development, and it has taken sexual reproductive health rights to a level involving even research, dissemination, and engaging various stakeholders, whether they are state or non-state actors. The program is currently being implemented in the East African community, ECOWAS. ECOWAS is an organization for West African states, SADC for the Southern African states, and one of the interventions under this program is the annual reproductive justice litigation Baraza, which we are holding today. This year's Baraza is themed Reimagining a Regional Afrocentric Approach to litigating reproductive justice through South-to-South knowledge exchange, and will focus on the development of reproductive justice litigation agenda and strategy for Africa, integrating lessons and strategies from other global South regions, including Asia and Latin America. And indeed, yesterday, those who were here, we learned a lot from the panelists from Latin America, where a lot of progress in the area of the right to health generally and sexual and reproductive health in particular have occurred. The courts there have seen an expanded interpretation of existing civil and political rights, such as the right to health. Yesterday, for example, we learned that relying on Article 4.1 of the American Convention on Human Rights, one of the courts handled a case against Costa Rica involving assisted reproductive technology, where the court found that an implanted embryo constitutes a personhood. So in other words, they use the right to life to tackle that situation. So we are going to learn a lot from our colleagues from Latin America. What they will tell us more. I haven't studied that in detail. So we hope to chart a litigation agenda to enrich, contextualize, and reform previous sexual reproductive health rights work on the continent through an African-centered viewpoint. Consequently, I would invite you to consider a number of issues in these 2 days when we shall be having this discourse. In what ways can post-colonial law rid itself of its colonial baggage? How has colonialism shaped our laws and judicial systems? When we talk about, for example, the struggle for access to safe legal abortion, when we talk about regulation or decriminalization of sex work, when we talk about criminalization of sexual orientation or gender identity, don't these have a root in colonialism? Are these issues surely an African, as some people would like to allege, or they were imposed on Africa by the colonialists? So how can we move on in that regard? We cannot deny the fact that colonialism has significantly influenced our laws and judicial systems, especially in the context of reproductive justice. And as I pointed out yesterday, though I use sexual reproductive health rights and reproductive justice interchangeably, I take into account the intersectionality involved in these matters so that we may adopt the view of the women of color who came up with the conceptualization of reproductive justice after the 1994 International Cairo Program of Professional Development Conference, where they said reproductive justice addresses 3 important questions. 1, the right to have a child. 2, the right not to have a child. And 3, the right to have a child in safe and healthy environments. So that we know that much as we talk about issues like access to safe legal abortion and others, we must look at other variables, including class, gender, sexual orientation, and others. We may need to look at the experiences of India, especially during the reign of Justice Bhagwati of the Supreme Court. How did India benefit from the expanded interpretation of the norms in their constitution? For example, the Indian constitution did not render the national objectives in their constitution as justiciable. But the Supreme Court recognize that those objectives are not in the Constitution just for decoration or to beautify it, but must be used for purposes of enhancing the human dignity of the people. So the Indian Supreme Court and the lower courts have expansively interpreted the right to life, freedom from cruel, inhuman, degrading treatment to encompass issues of reproductive justice. For example, sexual reproductive health rights are seen as part of the survival rights of the people. So what can we learn from India? India decolonized most of the laws, including in the area of commercial laws. What can we learn from India? The model that it offers in terms of implications for sexual reproductive health rights. But of course, India still has a lot of structural bottlenecks or barriers towards realization of these rights. How can we tackle the seemingly continuing debate between universalism and relativism in the human rights sphere? Arguments persist whether it is at the customary or cultural level, the Islamic perspective, some people saying some of the rights are foreign, they are not universal, that we need to localize. And as practitioners and scholars from the South, how can we ensure that we navigate this continuous debate between universalism and cultural relativism? We need to navigate this seeming tension to ensure that universal human rights standards are upheld while respecting progressive local cultural practices and norms. Because as people from the South, like from Africa here in Uganda, we should not look at our customary norms, values, and practices as entirely negative. To me, a people without a culture is a dead people. You need to belong to a culture. But what progressive cultural practices can we keep? And as customary practices, including law, develop, how can we discard those negative or retrogressive practices using constitutional standards? Because like in Uganda, our constitution, which I believe theoretically settled the universalism and relativism debate, clearly says any custom that is against provision of the Constitution, including the Bill of Rights, is void to the extent of its inconsistency. So even if the Constitution promotes the right to culture under Article 37, within the objectives of the Constitution, which are justiciable, it says only progressive values or customs practices shall be promoted. Of course, there is a challenge there. We have 54 ethnic groupings, which others call tribes. In Uganda, for example, do you have a uniform cultural standard which you can apply across those 54 tribes? I'm saying this because we saw this recently in the Anti-Homosexuality Act petition, the petition challenging the Anti-Homosexuality Act, where judges of the Constitutional Court, relying on Article 126, which says judicial or juridical power is derived from the people and shall be exercised in light of their values, traditions, and aspirations. How far do you go? Because we do not have uniform values and practices. So these are issues we need to look at for the lawyers and the judges. But the case, the petition has, the petitioners have appealed that to the Supreme Court. How can we utilize traditional legal systems vis-a-vis the international human rights perspectives? can we simply discard religion or culture, and yet they are roadblocks? I'm happy to report that in one of our organizations, Center for Human Rights and Development, I think there have been attempts, Nur will correct me, I think there have been attempts to engage religious leaders, starting with Muslim clerics who are progressive. Can we engage these religious leaders? Because if we simply leave them at bay, they'll continue being a roadblock to the realization of these rights. Yesterday, we learned from somebody from Latin America from the Catholic, what's that? Catholic Lawyers for Choice, or Catholic for Choice. Very interesting provision, a very interesting perspective, that if Mary, the mother of Jesus, was consulted by the angel before she could go into what she went through, why shouldn't I, as a woman, be consulted? And we found the same provisions in the Quran, Surah 19, 18 to 20. So how can we engage religious leaders, get some relevant scriptures from either the Bible, the Quran, or the Hadith, the sayings of the Prophet, peace be upon him, and we see how we can employ them? Because we cannot continue distancing ourselves from religious leaders. And yet this is very critical. I was happy, for example, this morning, when I saw a one Claire, who is a champion for LGBTQ rights, meeting the Pope at the Vatican and kissing the Pope, Pope Francis, a Jesuit Pope, who said, I am for everybody. Discrimination is a sin. So we need to engage these religious leaders because we cannot dodge them. What about the question of legal pluralism? We acquired these laws from our colonial masters. For example, Uganda was declared a protectorate in 1894. From 1894, we were under colonialism until 1962. Of course, in 1962, we obtained only what I call flag or political independence, and not independence in terms of the economy, etc. Now, how do we tackle that situation where English laws, including common law equity, were imposed on our country, and customary law values and practices were rendered subservient to colonial laws and subjected to the two tests which those who come from the English common law countries know, the repugnancy test and the incompatibility test. So our people had their own customary laws and values, and they were presented in that way. Many people in Africa still live by statutory laws imposed by the colonialists and the customary laws and practices. How can we leverage that? How can we balance that situation within the language of legal pluralism? Therefore, this includes exploring the potential role of traditional courts in addressing questions of sexual and reproductive health and rights. When you go to rural areas in Uganda, for example, or some other African countries I have visited, you'll find, like countries like Ghana, you find that kings, traditional leaders, play a lot of role, they have a lot of functions they play in the area of human lives. So we may need to, I'm about to finish, to explore what role they may play. How can we utilize regional and international collaboration? How can regional integration be leveraged to advance Africa's reproductive justice agenda? How can we rely on our own systems, institutions, and experts? How can we learn from the work of the African Commission on Human and People's Rights, the African Court on Human and People's Rights, the work of the special rapporteurs in Africa, and what lessons can we draw from other regions, Latin America? We have talked about Asia. What lessons can we draw from there? Lastly, it is essential to emphasize the importance of South-to-South knowledge exchange to ensure the replication of successes in other global South regions. On my side, I'm prepared to learn a lot from Latin America. I will be engaging Latin America. I need to learn a lot because my students continue referring to some of these cases, and as a teacher, I look ignorant, and you know that's dangerous. Okay? They really refer to this case. I need a lot, and I will be requesting you to exchange some literature on email. So constructive collaboration among these regions enables sharing best practices, successful strategies, and value experiences, ultimately contributing to advancing reproductive autonomy and health in diverse cultural contexts. This inclusive approach will facilitate learning from each other's achievements, challenges, and fostering mutual growth and progress in addressing reproductive justice issues. I wish you fruitful deliberations. Thank you very much.
Thank you very much, Professor Ben, for welcoming us on behalf of Haki, but also stressing the purpose of why we're here. We're here to dialogue, we're here to do a Baraza, we're here to exchange ideas, we are here to know what has worked elsewhere. I'll now take the opportunity to invite the Uganda Law Society to come and tell us, does something like litigating on reproductive justice truly and really exist on this part of the world, on the African continent? You are welcome.
Good morning, ladies and gentlemen. My name is Masco Godwin Muhwezi. I head litigation and professional development at the Uganda Law Society, and I'm here on behalf of our acting CEO who was unable to make it today. I stand on the protocol already observed, and I associate with what Professor has already said on the purpose of this Baraza and the history with the Haki. And on behalf of Uganda Law Society, who is a partner on this day, I welcome you all, especially those who are outside, from outside Uganda. I would say Karibu if it's South Africa. I would say Mukulikeyo, feel at home. This is Uganda, the Pearl of Africa. I hope you'll have a chance to explore a lot more outside this Baraza on the beauty that we have in this country. For us, as Uganda Law Society, we believe that this gathering reflects our shared commitment in advancing sexual reproductive health rights. And the theme is instructive in terms of where we are going, where we are thinking in terms of South-to-South collaboration. And this speaks specifically to the need to move away from the concerns of the global North-led interventions in our human rights litigation. As Uganda Law Society, we are a pivotal organization of over 6,000 lawyers. And when you include our honorable justices and judges here, we have a big alumni. But that's to say that we sit at the pivot of litigation as a toolbox for advancing reproductive justice. And it's an honor for us to be part of this conversation at this nascent stage. Through our Health and the Law cluster, which was founded by Dr. Mulumba and is now led by Mr. Ibrahim Sereko of Haki, as well as hosted by the Center for Human Rights, we are privileged to be part of what is going on, and we are happy that we're invited at the very beginning. We're part of last year's Baraza, and we're also part of this Baraza to see that we are given the platform to mainstream this conversation. And we want to thank the cluster for the tireless work that we've done the background to say that as of this year, we've been able to accredit this training as part of the compulsory continuous legal education training for all advocates. What that means for our context is that it helps us move this curriculum, this conversation into the space of what lawyers can interact with, can engage with, because when we start doing litigation, it's important that the judges are aware of what concerns we are dealing with, they are aware of the jurisprudence, the lawyers are able to interact with the primary text that we are dealing with, and as Uganda Law Society, we are happy for that progress. In our work with the Haki as well, we have been fortunate to work with them in case ideation and conceptualization cases that are coming up. And again, that is interesting in the sense that we are seeing that the work is coming from the ground up, the decisions, that the ideas are homegrown. We're able to see cases develop by Ugandans, by Ugandan stakeholders, by Ugandan partners. And so we are happy to say that we can own the products. It's no longer ideas that are passed down and people have to struggle with getting them across. So for us as Uganda Law Society, it's an honor to partner in this crucial endeavor. We recognize that access to justice is essential for realizing reproductive justice. And in our work, we have two aims, and we believe this is what we bring to the table. We will strengthen legal frameworks by advocating for laws and policies that protect and promote reproductive justice. Secondly, we will use our leverage and advocacy to ensure that marginalized communities, groups including women and young people, have access to legal services. This is through our legal aid project that we have across the country, but also through the strategic litigation department that I work with. Lastly, I would like to encourage the team here and everybody that for this movement to happen, for a lot of the work that we are doing, collaboration is key. And I'd like for us to take this opportunity in this Baraza as we learn. Let's network, let's see what's possible within our context with the partners that are here, so that as we come out of this place, we're able to have more collaborative opportunities. I'm confident that this Baraza will be a resounding success, looking at the panel and the people that are going to be presenting, and I wish all of you a successful session.
Thank you very much, Uganda Law Society, for the partnership, but also for indicating why we're here and also where that leads to. I'd like to take the opportunity to welcome the members of the Law Society who are not here, but I'm very well aware they are joining us online and virtually. You're welcome, learned friends. So I'll take us to the next person that is going to welcome us to this space. And now we are moving to the African Union. We're going to welcome the Commissioner of the African Commission on Human and People's Rights, who is also the chairperson of the Working Group on Economic, Social, and Cultural Rights. Honorable Madford, you are welcome.
Madam Moderator, distinguished participants, as you have heard, my name is Madford, but my full names are Madford Zakaria Mwandenga. Yes, indeed, I'm a commissioner at the African Commission of Human and People's Rights, and the chairperson of the Working Group on Economic, Social, and Cultural Rights. But those are part-time jobs that I do. And whilst at the Commission, I also deal with monitoring human rights situation in this country, Malawi, Ethiopia, and Rwanda, as well as Liberia. And for my full-time job, I'm actually a sitting Constitutional Court judge in the Republic of Zambia. So I've got a plate full of things that I do to keep going. Madam Moderator, distinguished participants, good morning. I cherish this opportunity to join those that have spoken before me to make opening remarks at this Baraza 2024. I too would like to extend a warm welcome to you gathered here, including the esteemed organizers of this very important event, as well as the distinguished, eminent, and well-versed resource persons who will be making presentations on various topics which will revolve around the important subject of reproductive justice. A look at the agenda for this Baraza suggests that the 3 days that we are going to spend together are bound to be very engaging and enriching to all of us present here. That you chose to accept the invitation by the esteemed organizers of this very important event to come and attend this Reproductive Justice Litigation Baraza 2024 speaks volumes of your interest in reproductive justice. My plea is that during the Baraza, you will be in a position to share your valuable insights on reproductive justice and matters connected and incidental thereto by making contributions to the discussions that will ensue. And at the end of the Baraza, you should be able to say that it was worth a while for you to attend this Baraza. It will be remiss on my part if I were to fail or neglect to say that for us as the African Commission on Human and People's Rights, we are thrilled to be part of this Baraza. We are thrilled because the African Commission on Human and People's Rights has also been undertaking activities that advance reproductive health. Such activities are carried out by the African Commission on Human and People's Rights within the framework of the mandate that it has under the African Charter on Human and People's Rights. In this regard, the African Commission on Human and People's Rights is interested in applying human rights to reproductive health. Therefore, reproductive justice is dear to the African Commission on Human and People's Rights because at a certain point in time, it may be necessary for reproductive rights to be enforced at the national level or at the level of the African Commission on Human and People's Rights, and indeed the African Courts on Human and People's Rights. Therefore, as the African Commission on Human and People's Rights, we see this Baraza as an activity that will go a long way in fostering its activities insofar as the promotion and protection of reproductive rights are concerned. But also, we are thrilled because this Baraza is about reproductive justice litigation. From my individual perspective, it is regrettable that human rights litigation at the national level or regional levels, perhaps let me zero it down, in my country, Zambia, seems to be viewed by many a profit-oriented legal practitioner. I hope the gentleman from Luganda Law Society, this applies to you, as being the type of litigation that does not assist a lawyer to bill the client profitably. Most lawyers are all about bidding, and most of the people that are involved in human rights litigation are people that cannot afford a lawyer. So that does not become attractive work for most lawyers. Therefore, I'm hoping that if we have such lawyers in this Baraza, they will, at the end of the day, rethink reproductive justice as one of the methods of assisting their clients litigate reproductive rights, issues at national level, and if need be there, could escalate their clients' cases to the African Commission on Human and People's Rights after exhausting local remedies. Once again, a warm welcome to you all, and I pray that you will have fruitful deliberations, and whatever you will learn from here will help in the promotion of reproductive justice in your respective countries. I look forward to the deliberations beginning, and thank you very much for lending me an ear to deliver these opening remarks. Thank you.
Thank you very much, Honorable Commissioner Madoff, for welcoming us from the Pan-African context and also from our regional economic bloc, the African Union. Now that we've gotten welcome remarks from Haki, from the Law Society, from Africa, it is time for us also to welcome each other here. This is a Baraza that is reimagining regional Afrocentric approaches to litigating reproductive justice through South-to-South exchange learning. For the first time, we are having 4 continents meeting in the Pearl of Africa to deliberate. Let us welcome each other. So, to enable you to take time to know each other, we're not going to introduce ourselves individually, but we're going to name the continents and the countries. When your country is named, please stand up for recognition. And others we clap because it takes a lot. For those of us who've traveled to Uganda, we know how many connections people took. I know some of you traveled for more than 30 hours to arrive in the Pearl of Africa. I hope it was worth it, and we have to make it worth it for you. So, if you're from Africa and Uganda, please prepare your hands you oil them to welcome the delegates. And we know in African culture, we welcome visitors very well. So I'll begin with our delegates that came in from Latin America. So in Latin America, we have Brazil, Argentina, Mexico. Well, those of you who speak English, you call it Mexico, but they call it Mexico. And those are our delegates that are coming in from Latin America. And welcome, welcome, welcome. Then we have delegates that are coming in from North America. We have from the United States of America. We have delegates from India. They are on the way here, but let's welcome them from Asia. And then we have us from Africa. We have from Zimbabwe. South Africa, Nigeria, Zambia, Rwanda, Uganda, and delegates that are joining us from what I conveniently call the United Nations, from across the world because they're joining us virtually. Let's also welcome them. So, now that we know that we are coming from various parts of the country, Kenya! Apologies. Apologies, I grew up in Kenya. From where? Oh, Malawi. Apologies to Malawi and Kenya. Sincere apologies. Malawi, okay. Let's give them their space. Malawi and Kenya. You are all welcome. If there's any country I've forgotten or somebody has not registered, we can always welcome each other along the way. So, I'm going to take now the opportunity, now that we know that we're all here, let's try as much as possible to connect. During the breaks, connect with each other, know who is next to you around your tables, but also in the breaks because we are here to knowledge exchange. We can't only knowledge exchange with people from our country or people that we're comfortable with. So I'd like to take the opportunity to invite the honor, to invite our host. I told you it's difficult to welcome your host to their own event. But, Dr. Mulumba, you sat for a whole year with your team and partners to come up with this Baraza, we really like to know, why are we here? Why did you choose this particular week? Why did you ask us to have this conversation? What is even a Baraza anyway? Because the word might seem foreign to some people, and for some people it might be clear. And then also, where do you see this going? How do we weave this from the last Baraza to this one, and where you see the future? Dr. Moses Mulumba, Director General of Haki, you are welcome.
Thank you very much, Solomon, our moderator this morning. I am beyond excited to be having the honor of welcoming you all to the Pearl of Africa, but most importantly to the Litigation Baraza. I will also stand on the protocol that has been highlighted, but in a special way, I want to recognize our keynote speaker that will be speaking to us, Anand Gruver from India, former Special Rapporteur on the right to health, and a practitioner that many of us have interacted with, and the honorable justices in this room, practitioners, friends, and comrades, those that have traveled the shortest distance and those that have traveled the longest distance. We are super excited to have you all this morning. I come from Uganda, a country that was colonized for 68 years. An individual that is 68 years old is pretty old. And it takes a lot of effort to unlearn what they have learned over the space of 68 years. I know that Latin America, Africa, India, and a couple of other countries were colonized for even longer. If shorter, it's not less than 50 years. So we come from countries that are seated on legal systems that washed away what they knew, and that was replaced by what they had to know for over 50 years. So the whole idea of the Litigation Baraza and our work on reproductive justice is anchored on the injustices, historical injustices and legacies that we have witnessed over the years by the legal systems that were introduced forcefully, in many cases, into our jurisdictions. And that's where we anchor this. In many cases, when you have a problem in the community where we come from, we cause meetings and talk about these problems. The word Baraza means to have a conversation. It's important that we have a conversation on some of the complex legal policy issues on sexual reproductive health and rights. I have told comrades that sexual reproductive health and rights, which includes maternal health, is not a disease. It's not a disease that it pops up and we have to find medical remedies. It's not a disease like coronavirus that we have to find a quick solution over a virus. It's part of society. It's part of human existence. What surprises is that even when it's part of society and human existence, we've never defined solutions to it. We quickly run into our beliefs that are entrenched in our minds, through our upbringing, through the colonial environment that we are exposed to define the problems and the solutions to deal with it. And the way it has been evolving over the years is that we've dealt with sexual reproductive health and rights through norms and taboos for a long time. And then these evolved into practices that we quickly called common law practices if we are colonized by the British. And now we have integrated these into our legal systems. This is not a Ugandan problem. It's not an African problem. A few months ago, the US has been grappling with how to deal with a judicial decision that has overturned Roe versus Wade. It's also touching on issues that are to do with sexual reproductive health and rights. And no one seems to know the solution, even after 50 years of people thinking that that's a settled position. It was never settled. A few months back, Uganda was faced with a challenge of dealing with another matter on sexual reproductive health and rights, on LGBTI issues. If you read the judgment, you become excited about the appeal and wait for what the judges will tell us on the appeal. So these are matters that are part of us. They are matters that are not a disease. They are matters that are not a public crisis. But they are matters that we need to find quick solutions or even long-term solutions too. There are two words in the litigation Baraza. The first was Baraza that I talked about. The second is litigation. For the lawyers, I think sometimes it's important that we get a little bit back into the history of the word litigation. And I was thinking about what litigation has meant historically and how it has been evolving. If you think about history and litigations, I think it goes back to ancient civilization, way back. In countries like Egypt, they had the Pharaoh, who was the judge. The Pharaoh was the Alpha and the Omega. We have systems that have kept that, where the judge is still the Alpha and the Omega on the matter when it comes. But we also had countries like Greece, which had not just a judge, but it had a jury system. And some countries have actually kept the jury system. And we've kept the jury systems in various ways. The peers meet, they hear the matter before them, and they form an opinion and make a decision. It was interesting to watch how the jury system in the US works. A few months back, when one of the people in the US, famous figure, former President Trump, had to deal with the matter. But that's very far. I always think about the jury system from a very simplistic way. Dr. Luswata is not yet here. But my colleagues who are in the medical fraternity have formed the Medical and Dental Practitioners Council that sits and forms an opinion on how a practice was either right or wrong. That's a kind of jury system that we never think about as a jury system. So, litigation sometimes has ended up in a single judge's decision or a group of judges' decisions or a jury system of peers that make a decision. And it's been evolving over the years. But what's clear is that people have sought justice. over all those years, and that there have been disputes that we've dealt with. But we used to look at these disputes as disputes between citizens for a long time. In the Middle Age, where the Catholic Church in Europe played a major role, before the monarchs created judicial systems, I think we also saw that justice was still between a person and how they were wronging the state. So it evolved a bit to move beyond litigating or dealing with legal issues between citizens to actually having the state play a major role and citizens and how they wrong the state. And I think that has evolved. I think the Industrial Revolution really changed very many things on disputes. We now have very specialized areas where we practice. And sexual reproductive health and rights is just one of those specialized areas. It's not just specialty in the areas, but it's also in the way the judicial systems operate. We now talk about alternative dispute resolution much more than ever. It's not a new issue. I think in the African societies, we had more alternative dispute resolution than anywhere. When we introduce it today and talk about it as a new issue, we forget our history. But it's now engraved and it's part of the practice. In fact, before you go through the mainstream court, you're required to have some kind of resolution. We have practice that is across jurisdictions. Litigation is no longer about people in the same jurisdiction. It's sometimes across jurisdictions. And we've created multiple layers. We now talk about national level litigations. We talk about sub-regional litigations in the East African community or ECOWAS or SADC. But we also talk about regional. The African Commission, the African Court, and all those platforms that are existing on the African continent. And I know that in Latin America, our colleagues have similar spaces. So litigation is much more complex. When you file a matter, it's no longer going before the judge and receiving a judgment. When you file it, another person will say, I'm also interested in the matter. Then you have other applications, amicus curiae. How do we deal with all those? On the subject of sexual reproductive health and rights, how do we have a conversation about this on sexual reproductive health and rights? We are dealing with sexual reproductive health and rights and litigations in a complex technological environment. Very complex assisted reproductive technology. These were never thought about before. They are before us. For the lawyers in practice, what does this mean? Health insurance, very big thing. In countries like the US, it's such a big, big issue. Here, the elite are all running with insurance cards to receive care. We have litigations on specific diseases, HIV/AIDS, which is linked somehow to sexual reproductive health and rights. It shows you how complex the matter we are talking about is and why it's even important to talk about this matter. I think that we need to look at this from the African point of view. And I'm happy that we've invited colleagues from other southern countries to come and we learn from them, but we also share and they learn from us. In a special way, this year's Litigation Baraza provides that opportunity. People that were part of the sessions yesterday, I've been meeting them over breakfast, and they told me what they learned yesterday they have not had, some in their 30 years of practice. That's amazing. We have moved from African traditional justice systems. We have challenges that we have to deal with that are continuing to be legacies of colonialism on the African continent that I've talked about. The advent of colonialism introduced huge, huge spaces that we need to deal with, the repugnance clauses that Professor Ben has talked about, are continuing to be a huge problem. The creation of judicial or creation of other justice actors like the police continues to be a big issue on sexual reproductive health and rights. If you think about the history of police, just police, Africa, and sexual reproductive health and rights, and colonialism, it gives an interesting picture. The police was created, in many cases, to protect the interests of the state, although they say interests of the citizens. I know that in Ghana, as it was being introduced in 1976, it was to protect the railway lines and the gold mines. Later on, it expanded. But now, the police has a major role to play in sexual reproductive health and rights. In Nigeria, there has been a movement that talks about the Special Anti-Robbery Squad and the SARS movement. It's the same thing, police. In Kenya, there have been campaigns, and Uganda, on anti-local government laws, on making noise on the street, public decency. And what do these mean for sexual reproductive health and rights in the eras that we are talking about? We have to answer the question, is it our laws? Is it their laws? We continue to have a legacy of their laws in many ways. When do we have our own laws to deal with sexual reproductive health and rights? If we make our laws, do we make them our laws? And what mechanisms do we have to make them our laws? I think the last point for me, which will be talked about in the Baraza, is the aspect of public interest. I think very many of our constitutions have been built on the Westminster style, the executive, the legislature, and the judiciary. And because I'm talking about litigation today, I'll just highlight the role of the judges. Last week, I was privileged to be in a meeting where the Minister of Justice was, and he reminded us that judges are humans. And it's very difficult for us to think about judges as people who are, he used the word neutral. And he was wondering whether judges can be neutral in face of controversies that they face. They have political feelings. They equally have social feelings. And they remain humans. So when it comes to public interest litigations, I think it's very difficult for us to speculate that the law can be insulated of politics, economics, and social change. And therefore, the role of public interest lawyering becomes important. In the role of public interest lawyering, we have the lawyer. Some of you that know public interest lawyers have a historical thing. In the US Black history, there is a lot of public interest lawyers that are very famous. In South Africa, anti-apartheid regimes, you know that public interest lawyers played a major role. In our countries, Uganda, Kenya, now public interest litigation lawyers are playing a major role. And this spreads across. What is our role in all of this? What have we seen in the past, and what do we see in the future? I think that we have a real opportunity to talk about these things in a complex, contested area of sexual reproductive health and rights. I don't have answers to any of what I have asked. But I want to thank the partners that have accepted to come in this Baraza. I only want to give you an assurance that you're going to hear what you like and what you don't like. It's going to be interesting, but like lawyers, in many cases, we defend what we don't like because we have to defend. And it's part of the role that we play. So partners from Rios, we very much thank you for commitment to come down here. Our partners from Face Formista, our partners from SEHAD and the Preclusion Project, we are super excited to have you as partners that we roll on this year's Litigation Baraza. I want to thank the Uganda Law Society in a special way. I have told students, and I've taught for now 15 years in law school, that lawyering is no longer about transactions. Yes, it can be transactions, but transactions are complicated. Think about transactions in sexual reproductive health and rights, where you have a reproductive assisted technology issue involving people. You have to read a lot about sexual reproductive health and rights. So Uganda Law Society, the decision to move beyond commercial, traditional transactions on land and banking and insurance towards sophisticated, complicated, ununderstood, contested issues of sexual reproductive health and rights, I think is the way to go. You are opening up the space to young lawyers to begin a practice that has not been traditionally thought about. I come from a Haki where we are interested in 4 things: positive African narratives. I would be excited to hear about the positive judgments that Africans have made on sexual reproductive health and rights. We are interested in African institutions and the role of African institutions. The second issue. And the third issue, we are very much interested in the African individual and the capacity of the African individuals to navigate their way through complicated issues like these that we are covering this year. And the fourth issue we are interested in is the role of organizations and entities, whether academic or civil society organizations. So I welcome you all, and I look forward to rolling with you in this year's Litigation Baraza. Thank you very much.
Thank you, Dr. Mlumba, for welcoming us to the Baraza and for allowing us to break down the concept note. We received a concept note. If you don't have it, it's part of the program that tells us why we are here, how we got here, where we are heading, but even also challenging us with questions that do not have answers. Nonetheless, the agenda that we have for the next 3 days will enable us come up with answers, and even if we do not have the answers, we are going to surface those issues and work with them. And for those of us that have just arrived, we have your notebook, you have a pen, you have, and the notebook has you have a program which is part of the concept note. And for those of us that love pictures, we have a booth outside. Please make use of it during your breaks and lunch times. We have our bathrooms that are outside, but also more importantly, we have ourselves here to learn, unlearn, relearn, dialogue, and reflect. So I'd like you to give a big applause to the opening panel. The opening panel has really set pace, and I think we are now a bit settled. We know why we are here and that you're in safe hands, but also how exciting the next 3 days are going to be as 4 continents learn from each other and share what has worked and also what we need to do together moving forward. So I'd like now to request my panel to take back their seats. Thank you very much. And take us into the next, now we've, the next session, which is going to be the first session. I know in your programs, you will see the keynote address, but just like indicated, Africa travel is very hectic. So our keynote speaker is held up somewhere by an airline somewhere. Nonetheless, we've adjusted that keynote session to tomorrow morning to allow them arrive in the Pearl of Africa in good time. It's totally beyond our control, and we can't control that with Africa travel. So we're going to sail through. The good thing with us in this room is that we are able to adapt. The capacity to adapt is one of the things that allows us to move into the future. And we're going to move into the first session, panel session, which is really around challenging colonial legacy and leveraging strategic litigation to advance sexual and reproductive health and rights and reproductive justice in post-colonial Africa. This particular panel is going to be moderated by Dr. Adrian Juko. Dr. Adrian Juko is the Executive Director and founder of the Human Rights Awareness and Promotion Forum, HIRAF. He is a litigant. For all the years I've met Adrian, when we were both young, now we are a bit youngish. He has litigated. And he's going to moderate a panel of people that are in that area and are going to tell us what has worked. I do not have the moral authority to introduce or invite Dr. Adrian's panel. Dr. Adrian, you're welcome, and the floor is yours for your panel.
Thank you so much, Salome, and good morning. Good morning. Hey, happy faces, you see, it's the first panel, so you should be excited and happy about it. So like Soma has introduced the panel, we're going to discuss challenging the colonial legacy, leveraging strategic litigation to advance sexual and reproductive health rights and reproductive justice in post-colonial Africa. So the panel is not just about Uganda, it's a panel that's African, but also international at the same time. Some of the things that we usually think about when we think of strategic litigation is where does it stand in the framing of post-coloniality? What does litigation mean for us? Is it a tool from the West? And if it's a tool from the West, how do we then use it as people from the South? That's the dilemma that the African today finds themselves in. The African social justice activist, the African reproductive justice activist, the African litigator. Aren't we using the tools of the master to dismantle the master's house? And can they do this if we do this? And what does this actually mean? In a country, in a continent, where coloniality is so entrenched that we are using English as our language, as if we have no African languages to use, where our education system is based on our Western values and Western standards, where we got courts of law that are formulated and were started by Europeans during colonialism. How can we then have an Afrocentric approach in this kind of situation? That is the question. Can we actually use the master's tools, maybe shape them in a way that they're no longer the master's tools, but we are now the masters of the tools? So we have a panel that's going to discuss these questions for us, how we can turn these tools into our own tools, or how we've been actually doing this, turning the tools into our own tools. So the panel is made up of 4 eminent persons. The first one is Namyalo Hadija Ganafa. Hadija, please welcome to the podium. Hadija is a Ugandan lawyer, academic and lecturer at Mackay University School of Law. She's currently a PhD candidate at the University of Warwick, and she's been involved in several consultancies focused on access to justice for vulnerable groups such as women and persons with disabilities, human rights, migration, and gender-based violence. And her interest in Afrocentrism was sparked during her fellowship with Afya na Haki. Hadija, welcome. And then next to Hadija is Nyokabi Njogu. Hey, we are now going beyond Uganda. Nyokabi is a feminist lawyer and trailblazer in the field of strategic litigation. She leads the strategic litigation unit at the Kenya Legal and Ethical Issues Network on HIV and AIDS, that is KELIN. And she's an advocate of the High Court of Kenya and an alumni of the Feminist Litigation Network of the Initiative for Strategic Litigation in Africa. And her research and strategic litigation work are driving social change and advocating for women's rights. So welcome, Nyokabi. And then we have Ban Ruth Snyder, someone with whom we run the streets in Washington, D.C., doing advocacy at Capitol Hill and other places. Ban is an experienced advisor and strategist working at the intersections of HIV, AIDS, US foreign policy, abortion rights, and the law. She's the senior director at the Preclusion Project and the senior policy fellow at the Council for Global Equality. She's previously been the director of public policy for change and managing attorney of the Center for HIV Law and Policy, and served as counsel on the Chicago 2016 Olympic bid. Hey, there we are. She has written pieces in The Hill, The Guardian, and The Washington Blade, and published articles on Trump's global gag rule in Think Global, Health and Sexual Imperative Health Matters. And she has a BA in politics from Elham College and a Jewish doctor and a certificate in refugees and humanitarian emergencies from Georgetown University Law Center. And then last but not least is Honorable Justice Eva Luswata. Her Lordship is a judge of the Court of Appeal of Uganda and she holds an LLM from the University of Pretoria, a PGD from the University of Zimbabwe, and an LB from Makerere University. She's the LDC Advisory Board Chairperson on Pro Bono Legal Education. She's also been a visiting lecturer on gender and human rights at Makerere University and served as legal counsel at the International Criminal Court. As you can see, our panel made up of all ladies is very, very accomplished. It's not a man of this time round, it's all ladies, and that's very important. So thank you, ladies, for joining me today. And we are going to discuss this important question. Hadija, I called you first, right? So I'm going to let you speak first for about 5 to 7 minutes on what you think about this. Thank you.
Good morning, ladies and gentlemen. I'll stick to the protocol as observed. And today I'm interested in looking at Afrocentrism as a conceptual theory and tool for advocating or advancing reproductive justice in Africa. And before we proceed, I think it's important for all of us to appreciate what Afrocentrism involves. And this basically looks at Africa, African experiences, values, and perspectives. There's a difference between Afrocentrism and Africentrism. And today we are focused on Afrocentrism because we believe that Africa deserves a place at the table. And to gain this place, it means that whatever we do, whatever we lobby for, whatever we want, has to have African interests, experiences, values, and expectations at the forefront. So using this as a theoretical framework or as a theory requires us to go back and question, why do we want to put this at the table? It is important, like Dr. Mulumba mentioned, to challenge colonial legacies, because we got independence, but from what? We did not get independence from everything because of coloniality, as mentioned by Dr. Adrian. And coloniality has different perspectives, but today we shall concentrate on coloniality of power, as explained by Annibal, who mentions that this kind of positions colonizers against the colonized. So upon gaining independence as African states, the colonizer merely handed over the television set, but remained with the remote control. And for those that have watched televisions that have nothing to do with remote controls know what it means. Because as children in the 80s, you had to wait for the TV to start at 5 p.m. You had to bathe, do your homework, sit and wait for the screen. It used to have a colorful curtain. And then when it starts, you cannot change. But today's children have the ability to change, because as you're watching your 9 p.m. news, they get the channel, press it, and there we go. So that is what the colonizer is doing. You want your independence, take it. But we still have the remote control. And how do we have this remote control? For starters, Africa was artificially demarcated. We all know that. And as we ponder or look at existing research, in the beginning, most of the research focused on this forceful artificial demarcation. And that meant that there were a lot of border conflicts. So a lot of research concentrated on fighting for the borders. And that created a narrative, which is Africa is violent. So concentrating on violent Africa meant that the most important perspectives, such as healthcare, the right to enjoy and make decisions which relate to reproductive justice, like to have children or not to have children, or to raise children in a good, safe environment, were never considered. So using Afrocentrism as a theory is therefore important because it will create positive African narratives. We can then go away from the border and move to what is important, which is healthcare. The other issue is we know that colonialism extended through divide and rule. And this divide and rule meant that people were trying to position themselves to remain in favorable books of the colonizer. That led to social stratification, the have and have-nots. So we have the modern is what comes from the global north. And the traditional or something that needs to be developed or modernized is what comes from the global south. So this divide and rule remains in place. But remember that Africa is not a homogeneous community, it's heterogeneous. So we have different cultures. And that border division may also be a blessing in disguise, because when we look at the Maragoli, we know that we have Maragoli in Uganda and Maragoli in Kenya, okay? And so many other border communities. Can that therefore mean that we share the same values as Africans? If the answer to that is yes, it means that Afrocentrism is the ideal theory that we should use to advance reproductive justice. One thing that remains important is that upon leaving Africa, the colonizer went with the most important thing, which is the economics or the financial. We all know that most of the African countries largely depend on foreign aid and loans to fund their health sector. And that leaves us as dependents. If we are dependents, it's time for our voices to be heard. How will our voices be heard if we are sitting and waiting to be given? Our voices can be heard through Afrocentrism. And like I've mentioned, that includes creating positive narratives about Africa, but you cannot create positive narratives about Africa without understanding what our problems are, what our needs are. And that is where organizations such as Afya and Haki come into place, because they have the evidence generation department, which is basically doing research, not only in Uganda, but everywhere where the LIRA program operates, so that they understand the lived realities of Africans. What are their needs? What do they want? And using this, they leverage on the expertise of Africans who understand how the system operates. That means looking at individuals and organizations that have expertise in Africa instead of relying on technical expertise from international organizations. When you look at most of the loans and aid that we receive, it's in form of technical expertise. And that therefore means that they bring someone who is paid 10 to 20 times more than an African would be paid, but you have to pay back that loan in the future, or you have to do what the donor wants. So one of the ways that Africans are using this or leveraging on expertise is through collaborations, like we see at this Baraza. So the South to South is very important because, like I've mentioned, coloniality is a concept that's developed from South America. And that therefore means they have a lot to learn from each other. And like you've heard, we have a team coming from India, which is setting the pace for several things that happen in this sphere. Afrocentrism intersects with several forms of identity and oppression, and that is why it's important to be used as a framework. Because when we merely adopt Eurocentric approaches and theoretical frameworks to address our needs, they lack the local context and therefore remain irrelevant. And that is one of the reasons why we still struggle with dealing with our health challenges or dealing with development or actually enjoying the benefits that should be brought about by international loans, donor funding, etc. So how then can we use Afrocentrism as a theoretical framework or even a tool for advancing reproductive justice in Africa? That can be done through policy and practice. For example, we should localize our health care models. We should integrate traditional practices with modern health interventions and also advocate for community-driven reproductive health strategies. Litigation is another thing that is very important because for those who are practicing law, you always rely on precedent. And when you rely on precedent, most of this precedent is derived from the global north. So without creating your own precedent in the global south, it means the colonizer remains powerful. That is why it is important for us to appreciate the LIRA program so that we see what comes out of the litigation in the different parts of Africa where this program is taking place. Another issue is about positioning yourselves as Africans. And of course, one of the things that creates impact is the narrative that's created. For those of you that enjoy reading publications by the World Bank, they usually have very good numbers. They did research in 100 and something countries, and Africa struggles with healthcare access, and the reasons for healthcare access include, I'm about to finish, include corruption, etc., etc. So, positionality or positioning Africans at the center is important. And it's exciting to know that African CSOs are now in the right places at a regional and international level. For example, Haki has observer status before the African Commission on Human and People's Rights, and that therefore means they can participate in the public discussions and provide the evidence generated through their research. And also looking at its membership, the World Health Organization on the Civil Society Commission, that means that the Afrocentric values, approaches, and desires and perspectives are put at the international level. Most of all, as we utilize this as a theory or tool to advocate for RJ in Africa, we should ensure that there is equity and inclusivity. Because when the colonizer came to colonize us, they were interested in making Africa a place where they can extract, and to date, extraction occurs. So we should ensure that the needs of the marginalized and vulnerable groups are at the center. Thank you very much, ladies and gentlemen.
Thank you very much, Hadija, for that insight in Afrocentrism. And Nyokabi, now this comes to you. She has laid the ground. She has talked of litigation and creating precedents, our own precedents. Are there any precedents? Is there anything we've done?
So thank you, Dr. Juko, and thank you to the previous panelists. I think the question is, are there any precedent? I think we are here because there is precedent. And when we look at it, I think we can frame it like broadly within three themes. First is the challenges around the criminality of reproductive health, or sexual and reproductive health. In Kenya, for example, we've got 2 very good cases that have come out from our courts in the last 5 years, challenging criminal law applications to abortion. We have one very bad precedent that has come out where the courts refused to acknowledge the colonial era law and the harm that it makes, and that particular law prohibits consensual same-sex relationships. Despite the fact that the court actually noted that these particular provisions of the law were colonial era, but it keeps talking about it in 2019 as the prevailing context within which we must look at sexual relationships. And that in itself, for me, is a blow to Afrocentrism. But when you think about also how criminal law approaches are used to control reproductive health, think about abortion, for example. We use the same law promulgated in 1960 when Kenya was just coming out of a state of emergency imposed by a colonial government. And that is the frame within which we're having to litigate reproductive health and rights. We know that colonial era laws, they were meant to control us. Colonialism, it was an extractive process intended to control women, and that fight on women's bodies is continuing to date. So when you think about having to litigate abortion in this context, for me, I think as a woman and as a feminist, it's an extremely difficult thing, because for women, we have to demonstrate that there has been some sort of violence before we can make a choice. And that is it's something that is completely antithetical to what we're trying to do. There have been gains. I am not discounting that, of course. But the fact that even our African regional standard talks about the right to abortion within the context of rape, or any other sexual violence, I think there is a big opportunity for us to think about what we can litigate there. There's also the questions of religion and morality. In the Regitary case, which I've alluded to, as well as in the abortion cases, there's been a challenge and a tension by the courts considering what religion or morality should or ought to be. And I think the question for us is in those cases, in as much as the two have been successful, we need to ask ourselves whose morality and whose religion, and to what extent are we also conflating traditional African religion or traditional African morality with what has been imposed on us by the religion that we go to church, when we pray to God. So we need to think about what are these contestations within those two, and how then can we ensure that our courts are actually properly appreciating what African traditional morality can or ought to be. We know abortion is not something that was alien. It was practiced in traditional contexts prior to colonialism. Of course, that was a question of privacy within the woman and the person who would administer the abortion, and that was really a private affair. But not so these days. The fact that we have police control, for me, is something that we really need to think about. And I say this knowing that the courts are becoming conduits through which I'm trying to be politically correct. I'm sorry, because I don't want to say what I've written here. But basically, we need to think about the role of the courts in also undermining rights. We had a fantastic judgment in the PAK, judgment litigated by our partners, where the question of abortion was actually framed as a question of privacy. And while the court did not really allude to what was in the Maputo Protocol, and in that case, by the way, the petitioner had actually suffered sexual violence and was therefore entitled to receive post-abortion care, that particular decision has been stayed. And the things that have been stayed within the judgment is not just about whether or not the girl could have had an abortion. It's also other things, for example, like the search of a woman's body to get evidence to incriminate her as having performed the procedure or having gotten the procedure. And that is why I say, I think in terms of, we've got the good precedent, but what additional administrative, legal, structural barriers are we putting in place that continue to enable the violation of the rights of women and girls? I think my second broad theme around the litigation that has been happened is around failing to recognize agency of adolescents as people who are growing up and who need sexual and reproductive health rights because they have needs. Like we've had, sexual and reproductive health is something that is inherent within us. In Kenya, for example, adolescent consensual, so non-coercive sex is not a crime, but that has come out of a long period of litigation that started in 2014 because our Sexual Offences Act did not make room for adolescents to engage in consensual sex. A lot of times, one of the parties would always end up in court. And while that has been corrected by the courts, a court in Western Kenya that said that it was absurd to actually criminalize one adolescent when there was evidence that it was consensual and therefore non-coercive, there's still a problem. While this adolescent cannot be charged, they still find themselves in a situation where they are taken through a process we call diversion. Through the state agencies, they are still required to go. It's not a criminal process, so they won't have a charge. But the thing is that they still have to go through a criminal law process that involves counseling, which may be good, but it can be a barrier. Because what does it mean for comprehensive sexuality education? What does it mean where now we've got law that requires third-party or parental consent for access to reproductive health for adolescents? So that's just an opportunity right there. So it's something we need to think about. And one of the cases I think for me is that has been integral in how we view or how we argue adolescent sexuality education or adolescent sexual and reproductive health is a teddy bear case from South Africa, where it talks about the need to ensure, on a basis of dignity, privacy, autonomy, that adolescents are able to carry out their sexual rights. And thirdly is around the discrimination frames. It's easy to consider women and girls as just women and girls, as if they don't have peculiarities within themselves. We know nobody lives single-issue lives. In Kelly's litigation on forced and coerced sterilization, this is one of the things that we really had to be able to nuance. Those particular cases were successful in some way, and they involved the challenge on forced sterilization on women living with HIV as they were going to give birth. So frames of obstetric violence. It's important for us as litigators to be able to demonstrate to courts the different lived realities of the women who are coming to us. As lawyers, it's easy to just see the problem and attack it. But as we think about Afrocentric approaches, it's to be able to demonstrate to court that this woman, who is poor for a certain reason, whose health status is affecting how she is actually getting access to health services, and that in itself, therefore, creates an opportunity for the court to develop jurisprudence identifying this person as a multifaceted woman and how denial of a reproductive health service can specifically affect her more than it would affect the classed woman who is living in New York, for example. So it's one of the things that we really need to think about. For us, and my time is almost up, I think some additional things that we need to consider: the use of police in terms of enforcing or preventing sexual and reproductive health. But more broadly, we also need to think about how our healthcare is funded. I'm sure in Uganda, like in many countries in Africa, maternal and reproductive health is funded through donor agencies. And what does that mean where access to medicine is violated? What are the commodities that we can definitely think about? Allow me to stop there, but I'm happy to take questions after.
Thank you so much, Nyokabi, for that perspective. I'm going to go on to the judge because we have had a litigator. Now, looking in from the bench, what do we think we can do better? What have we done wrong? What can we do better?
I'm sorry, I'm a bit old school, so let me just switch on my computer. But good morning, everyone. I have been introduced. I put my thoughts together in a PowerPoint, but I'll just be using it from here. And I'm glad when I looked at the concept paper that the background really came from, starting from the African Contemporary Society and the approaches we used to use back then. How did we manage these rights, the issues of rites of passage, traditional medicines, community education? You must understand that judges don't work in a vacuum. Judges have backgrounds. They have backgrounds. They have cultural backgrounds. They have political, religious, jurisprudential, career backgrounds. And my background was in litigation. So when I joined the bench, I had to work very hard to get rid of it. I know my sister there was a prosecutor. Susan was a prosecutor. I know whenever I would meet in criminal sessions, I would tend to, not to be biased, but because of my background, I tended to listen much more to the defense and the other side, So you must understand that judges are not gods. So when they approach some of these things, they have that influence. There's been a lot of talk on abortion rights. and it's quite an interest, by the way. When I was joining the bench and I went for my interview, they looked at me straight in the eye and asked me, what are your views about abortion? I mean, I had prepared so much on the court system, what are my duties as a judge, but because I had a human rights background, I looked back at them in the eye and said exactly what I felt we should be doing about abortion. And I was sweating afterwards. I said, I'm done. They're not going to give me this job. Probably I impressed them because if the whole bench don't want to listen, they know there will be some voices. Some voices are there that are going to advance constitutionalism. So these things are very important to us. And getting to work with people like you here now and maybe in the courts is very, very useful for us as members of the bench. I'm just going to give a very quick overview of what is happening in our courts. I can't speak for all the cases. I know Afya, I'm sorry I call you Sehud sometimes, I think you know. Afya and Haki does have a catalog of all of that. But I know that public interest litigation or strategic litigation is an avenue to constructively litigate. And for us courts, we have to sit and wait for you to come to us. So the practitioners are very important. You must do a lot of work with these practitioners because many, the people who are sitting at the bench, God forbid, we did not receive instruction in human rights at university. And probably those who are retired. More and more are coming up who did. I have my young lady there, and even now, there are lawyers who don't opt at all to get instruction at school because they are more interested in the commercial laws, and that's their choice. So, some of us end up at the bench without that background. So it is very important that we get those litigators who are going to guide the courts, constructively. And what has been happening in the courts? What has been happening in the courts? There's been development. We did not have the pre-colonial laws really worked around public health, administration, not so much about the right to health. And surprisingly, when our constitution came into force, it did not specifically make provision. I think you're all aware of that. And that was a problem to begin with. And thanks to this litigation, we have given life to our constitution in this area. And the courts have listened. We have this case of Sehud versus Nakaseke on obstetric care. Those are some of the early cases that came. And the courts began slowly. Negligence at a medical facility was now looked at, as something that has a direct impact on the health. It was just one lady who came, but the judgment then considered it in a more wholesome way. And the right to health was equated to dignity. And they held that, women have to access adequate maternal care. Then, of course, we as jurisprudential discourse started, we had the Tinyemfunza case, you heard about that one, and the question of the political question doctrine. Can the courts really intervene in matters of policy? And I think that has happened to other countries around the world. And in that case, of course, those were the early years, 2011, the court said, no, please stay away, you are interfering with the separation of powers. The court should not interfere in those matters. So things seem to have gone back to limbo, but thank you once again to the lawyers working in this area. We then started getting Professor and his group and Sehud. Over the years, they have been coming. They come, they are hit, they go back, they come back again, better the next time. And until the courts are now recognizing that, yes, even if we do not have the right to health, specifically enshrined in the Bill of Rights, we do have all those other rights which can be interpreted together with it. We do have the national objectives, and I think somebody from another country talked about it. The national objectives must be respected. And I think one of those cases, the Constitutional Court had agreed with the Attorney General that no, these are areas that the court cannot intervene, and it went on appeal. And fortunately, the Supreme Court decided that no, the courts must be allowed to act as legislators on policy where it is necessary, because if we don't do this and the state is slow to do it, then constitutionalism is going to go underground. So there have been very progressive judgments, and these judgments went into questions of budgets. So they were saying lack of resources in maternal and reproductive health care is a barrier for women to achieve these rights. And that if the government omits to provide, then it is violating the right. And the government was directed to prioritize and provide sufficient funds in the national budget and proper training of healthcare personnel. And of course, there was an interdict given to police the government for a period of about 2 years. And then, of course, issues of progressive realization of the rights. Of course, the Attorney General was always saying, hey, we have so many, we have so many demands on the budget. So issues of progressive realization were also considered, and the concept of resources. So judges are now being asked to understand things of economics, things of policy, as never before. And as they interrogated these rights, I've seen the case of Asero Ochain and the one of Mubangizi, where issues of access to information, things on postnatal care, people who want to contraceptive information on when you have your child, all these things are now within the realm of human rights. So what do we as judges, what must we do? Okay, judges must practice activism. You can call it judicial activism, you can call it whatever name it is, because we are the ones best placed to address the gaps and uncertainties. The lawyers will come to us and bring all these issues. We have to sit down and then advance the law with our pen. Okay, we can provide checks and balances against the effects of some of these archaic laws. And proactive judges can correct certain injustices, not for that one woman, but for all the people, vulnerable people who want to realize the right to health. And maybe to answer my sister from Kenya, you asked the question, what morality when it comes to issues of, for example, abortion? And I picked this up from India. Maybe our friends from India will develop on it. They call it morality of the Constitution. I was so taken aback by that. If you are stuck, it is the morality of the Constitution, not the morality of the public, not you as the judicial officer, not you as the litigant. What is the Constitution saying? What is the Constitution of Uganda saying? We say we have a good Constitution. It's pregnant with morality, with equality paradigms. Why do we have to look elsewhere? I think I've done that. So we can expand a decision beyond that one person who has come before you, beyond that issue that is before you, so that lives of many can be vindicated. Those are some of the things we can use. The use of interdicts. I think somebody talked about that. To monitor compliance is critical, and our court has done so. Whether, I understand the one in Mulago, the reports are coming in. I don't know whether they are still coming in. Sometimes it becomes difficult for us to go out of our courts because, once you make a judgment, you are functus. We call it funct. Your hands are tied, but you're saying no. That means we are giving judgments in vain. So proactive use of interdicts. We've talked about alternative dispute resolution. It is a big thing now in the judiciary. And we are, the CJ has always said, we must copy from where we came from in Africa. And somehow I always sat and said, where isn't he taking us? Where is he taking us? But now I've heard about the conversation of Afrocentism, things I had never thought about before, and it is very important. The issue of training. You must train judicial officers. I think we are only 2 or 3 here. Please invite more of our judicial officers right through the ranks to barazas like this, and you don't know what they can pick up. The issue of amicus curiae has been talked about. It is still quite in infancy in Uganda, and entry is still by application. Of course, there's I think the Supreme Court said, no, you can just come, but the practice is they can come by application, and I think the activists here, the lawyers here know how to engage. Amicus curiae is very important because you can then assist the courts on matters of law. Expert assistance on non-legal matters is still resisted, but I think you can be adventurous. You can bring out these issues, and like I told you, many of some of our judicial officers may not really have studied well on these things, and amicus curiae can be very important. Thank you very much.
Thank you so much. Ban, it's now your turn. You've heard all of it, the conceptual framework, the experiences, and the advice from the judge. Are there any looming threats we should be aware of?
Yes, as always, I am here to depress everyone, with apologies as always. So who are the neo-colonial actors that are interfering now? Because we want to talk about post-colonialism as a linear movement towards justice, but it is not, and there are new threats to how reproductive justice and reproductive litigation can go on in an Afrocentric way, in any way, in the coming years. If I asked you all to list some of the neo-colonial actors and threats, we could do this for most of the rest of the day, but I'm going to really highlight a couple instruments and actors and threats, and talk tomorrow much more about the looming threat of the global gag rule and the power of US funding as a neo-colonial threat. Today, I'm going to talk a little bit more about a couple of state and non-state actors, and in particular, how they swap from being a state actor to a non-state actor and continue their work in Uganda, in Kenya, in the continent in general. So the Geneva Consensus Declaration, how many people in the room have heard of it? How many people in the room have contemplated suing someone over it? Okay, we're gonna change those numbers today. So the Geneva Consensus Declaration is not from Geneva, it is not a consensus, and it is barely a declaration, but it is a threat to all of the work that we are doing here in this room. The goal of it is to disrupt international law and norms, and it's not a negotiated agreement. It was drafted unilaterally by the Trump administration in 2020, and it was signed by who knows who in governments from 33 different countries, including almost all of the ones who were named in our introductions this morning. So it uses human rights language and language as a declaration on women's health to dismantle human rights law, and national sovereignty language to further a very specific American white Christian nationalist view of family and women's health. It was championed by the Trump administration official Valerie Huber, and she continues to travel and promote the document as we speak. She and other Trump administration officials contributed to something called Project 2025, which is a massive plan for an anti-democratic and anti-rights future for the US. That Project 2025 sections on US foreign policy further and enshrine the Geneva Consensus Declaration and a Commission on Unalienable Rights, which in the United States, in the Trump administration, created a hierarchy of rights which excludes entirely sexual and reproductive health and rights and LGBT rights as contentious social issues while prioritizing property rights and a very specific type of religious freedom. So if the US kept to the US, I would not need to be sharing with you right now. But the US provides almost 50% of the health funding for Uganda, and close to that in several other of the countries and health systems that we've been talking about today. Project 2025 then tethers the foreign policy priorities and funding in their vision of a conservative future for the United States, specifically to the Geneva Consensus Declaration and this hierarchy of human rights. So it's a short document. It reads kind of okay. If you are not an international human rights lawyer, if you haven't bled over the Maputo Protocol, it reads as kind of an okay document. But it excludes abortion entirely. It's unconnected to the laborious ICPD and negotiated documents at the regional level and the international level. And it looks to actively interrupt that formation of customary international law. So there's also a related instrument. I'm just gonna upfront all the bad news. And it's meant to supplant, similarly, all the standards and tools that folks have been working on at a national level and also the UNICEF level, the UNAIDS level, sort of where we've been building data around comprehensive sexuality education, where we've been building frameworks. And it's called some Protego, and it is really the instrumentalization of the Geneva Consensus Declaration. The Protego is also championed by Valerie Huber, and it's really this operationalization plan. It's for ministries of gender, ministries of health, ministries of justice, ministries of finance, and it's meant to make the Geneva Consensus Declaration as powerful and operational as quickly as possible. She sold it to the previous government of Guatemala, and she has an MOU with the government of Uganda. She has also been to Chad and Mali and South Sudan, and all the while peddling the Geneva Consensus Declaration and Protego as the defender of African values and of national sovereignty. Again, written entirely alone in Washington, DC. So, what to do with this neo-colonial wolf in sheep's clothing? One, put an air tag on her so we know where she is in the world and what trouble she is causing. But I urge us to think really creatively about legal opportunities. What does it mean to have someone who has had government power and financial power of the government of the United States, has enormous numbers of people, evangelical Americans with her on this, actively exporting and creating a new set of what they want to be the international norm that excludes reproductive justice entirely. It's a fake consensus document from the United States that should not supersede the Maputo Protocol. And these are anti-rights actors who should not be redefining reproductive rights. So as we think about how to use the law creatively and litigation creatively, we have to not just think about our opportunities to undo the colonial past, we also have to recognize our actual current neo-colonial threats who want to disrupt all the work that we are doing.
Right on cue, thank you so much. So there we are. I think I told you it's an impressive panel, and it is. So clap for the panel once again. So we have 15 minutes, and I want to use these minutes to hear from the audience. Ask the panelists any questions that you want, or make any contributions that you want. Oh, okay, there's already a hand up. All right. Nimrod, let's have you first. Others shall come here, and then there. Okay.
Thank you so much to the distinguished panel and to the moderator. I have a couple of questions. They can be answered by any of the panelists. So we seem to be caught in an ever-ending loop of colonialism and neocolonialism. We're still dealing with the legacy of colonialism in how we handle issues of SRHR. And we're now in the midst of a renewed assault from, like Byrne called them, the neo-colonial actors. How are we going to make sure that, how can we deal with those? How can we deal with them and, once and decisively? Then the second question, I think we'll go to Lady Justice Luswata. What do you think a decolonized judiciary for purposes of SRHR looks like? Thank you.
Okay. Thank you. I think we can go here.
Thank you very much. Well, my concern stems from the morning session, but I think it may apply to some of you here. My concern is about promoting Afrocentism as a claim. It's a scholarly concern, and we all know that we cannot talk about scholarly work without doing through actual verbal rhetoric. As the professors were talking about the things, I've not heard of anything to do with archival research. We're all getting into history and all that kind of thing, but this has not been fronted. We've not talked about anthropology as a discipline or ethnography. I've worked at Makerere University, but I think 90% of the lecturers there are not even aware of this methodology, quite aware of it. So they should be training in this. Like, for instance, you should be developing curricula on legal anthropology, you take, for instance. And then, I won't go much into this in depth, but I think it's something of concern that you need to take note of, because it won't help us if we come and merely talk about this and without doing the actual work. We won't have the rich data enough to come up with new knowledge and new studies on this. And actually, much of the problem emanates from lack of data and information. There's very limited research here, and nobody is going to front your agenda when they don't even know what your interests are. Yeah, thank you.
Okay, Betty, yes.
Thank you so much. Mine goes to Lady Justice Luswata. Just reflecting on the recently concluded case of the constitutional case of AHA, where the judges or the justices hinged their decision around cultural and religious norms. What is the role of courts in terms of before actually deciding cases? Well, how can we as the society, civil society, how can the courts embrace issues of diversity? How can the courts embrace issues of inclusivity? How can courts embrace human rights aspects in deciding some of these cases, apart from hinging on some of these archaic cultural and religious norms in deciding some of these aspects? Thank you.
Thank you, Betty. Yes, Frida.
Thank you very much. Mine will quickly go to the last speaker, Bain Ruth Snyder. I hope I pronounced your name correctly. When you talk about the anti-rights that are promoting neo-colonialism back here in Africa, and what it is that we can do as a way to respond, but also as a means to decolonize and push back, I think we can do something back home. I am interested in what it is that can be done in the countries where the anti-rights are coming from. We have a precedent way back with a Scott Lively case. And I know that as much as we may not have got a lot out of it, there was precedent that was set. So I am interested in what it is that we can do with the country where the anti-rights are coming from.
All right. Kerigo, we are now on to you.
Thank you. Mine is also on the issue of the anti-rights actors. So I'm seeing the label changing constantly. Anti-rights, neo-colonial actors, it keeps opposition. And for me, I find it very intriguing that this conversation has actually been there from as early as 2009, when Kapi Kaoma documented the works of anti-rights actors in Africa. They were active when Kenya was trying to get the 2010 constitution. So I find myself asking a very interesting question is, why are we still, as pro-SRHR actors, we are still looking for strategies to respond? We've been documenting this for a while. Why are we still looking for strategies in 2024? Why haven't we found the strategies? Is it that finding the strategies forces us to have conversations around thinking about how we go about funding our advocacy work on SRHR? Because most of the funding comes with conditionalities around engaging with politics. Yet this whole thing is political, and that is what the neo-colonial actors, opposition, whatever we call them, are riding on. It's the politics of it. So what do we need to do? Again.
Okay, thank you. No? All right, let's have the last one here, and then we can have the panel respond. Here, right here.
Thank you so much, speakers, for that very enlightening sessions. I think we pick 1 or 2 lessons every time we listen in deeply. My concern is goes to Hadija Namialo. We talked about the neocolonialism effect of leaving us economically handicapped. They took the remote and left us with the television. Yes, so I'm just bothered about economic independence, because we can say all that we want, but if we do not have the money, we can't run the show. So how do we tackle this issue of, say, philanthropic funding within the African setup, or how do we boost our own funding base? Because for as long as we still rely on countries like the USA, we shall always rotate around, questions around supremacy and all this. So how do we put our minds together and to address this economic question or burden? Then the next one goes to Honorable Justice Eva, Lady Justice Eva. Oftentimes we've seen that courts are now progressing. They're trying to appreciate human rights, but we have a huge elephant in the room in terms of court judgments implementation. Especially judgment implementation. You'll have very progressive judgments against government, especially those brought against the Attorney General by different ministries, like if we're suing Ministry of Health, for example. But you'll find that they will keep being defiant. We won a case some years back on comprehensive sexuality education, and court directed Ministry of Education to develop a policy framework on comprehensive sexuality education, and they just went, silent. How do we collaboratively, strategically work to ensure that court judgments are not abused by especially those key political or state actors? Thank you.
Thank you, Dorothy. We have 5 minutes, panelists, and we have 5 of us. So 1 minute for each of us to respond, using your microphones right there.
I think the first two questions were really related. They wanted to know, how do we have a decolonized judiciary? And I think her question also related to that. We cannot forget, we cannot divorce ourselves from our culture, from our background, where we came from. Because when you even talk about Afrocentrism, the way we separate ourselves, for example, from the West, is because of our culture. So we cannot divorce ourselves from it. So a judiciary that must understand that, but then must also understand we can only harness what are some of the positive attributes that we can harness from where we came from our culture, but we must understand that rights have evolved. We have moved on, and that's why we have the constitutions we have. And so we must practice constitutionalism. This, when we adjudicate over these rights, we must embrace the Constitution and what it says about these rights. And like I said when I was speaking, we must embrace constitutional morality, because most of the drawbacks in these rights, really, when you go deep down to the foundation, it has everything to do with morality. The government probably, yes, won't give you money, but it's because the public is pushing back against some of these rights. We need to reflect on, yes, culture and the religious norms, but we must then understand that these cannot be drawbacks on the rights that we are supposed to protect. Judgment implementation, that's a very difficult one, because like I said, the courts stop somewhere. The courts stop somewhere, and then we leave it to the policymakers. But we have used interdicts, and I've said this is a very new area. So maybe we can be helped by the people who bring these courts to courts. Can you suggest proactive interdicts and guide the courts? You know, think through them before you bring them, because sometimes, because of too much work or maybe not being open to some of these things. But if we are guided, think about the interdicts that can work. And then I think collaboration with the policy, with the executive. I don't know how many you have invited here. Have you invited any in the health sector? So that they can appreciate some of these things out, because when we are in courts, we are combative. So the edge is going to go away in a combative manner and say, fine, I won't do it, even if they've ordered me. But if they've come and you have exchanged views in forums like this one, they will begin to appreciate that you do not bring these cases to court to embarrass the government, but to tell the state that you have certain obligations. Thank you.
Okay, moving quickly down the line. I don't have any perfect answers, and I look forward to talking more. I would say the US is at an unbelievably precarious moment, and our law is vibes at this point. Our constitutional principles are pretty much null, and all the things we learned in law school about standing and precedent are not a thing we can rely on anymore. So we have very few legal options in the United States when we're talking about these US citizen anti-rights actors and how they travel and the speech that they use. So we don't have any great legal strategies in the United States from which to tackle this, though we're working on it. But I do think that we have had a lot of new opportunities to really name and drag out into the light the radicalism. It seems very gauche to name someone by name and say this person is traveling the world trying to interfere with our rights, but we have to. We can't be polite about it. We've done a lot of work in the last year to name Project 2025, to make them own what their plans are for minority rights, for racial justice, for reproductive justice, and that is the most successful tactic that we have right now. And then we have to be really honest about where some of the money and influence and misinformation is coming from right now, what the networks look like, and again, drag it out into the light so we have a better opportunity to at least be honest about the Hungarian money that's coming to fund the anti-LGBT movement in the United States, about the oligarch money that's coming through the World Congress of Churches. So I think just being very bold in how we're talking about the threats that we're facing and who benefits financially and morally from these actors and what they're trying to accomplish.
So I will attempt to answer Dimrod's question around what does a decolonized judiciary look like? Acknowledging that we are using the oppressor's tool to fight for our freedom, I think we need, the judge talked about this training and this need for things like that, but we also need to think inwardly around the kind of tools that we are also using. We use regional instruments, we use international instruments. But we are going into a space where even those are not enough. I think we all know what, like the Special Rapporteur on Violence Against Women and what she said about sex work. What does that mean for us who are litigating for sexual and reproductive health rights in Africa? So we need to think, is that something that we want to rely on? For our judiciary also, you know, we talk, and I like that phrase, the constitution, you call it the constitutional morality. But our constitutions have what we call a proportionality test that is used to justify the limitation of rights. I would think, perhaps, we need to then start thinking about how to expand this proportionality test so that the instances for limitation of rights are so narrow. But that work, unfortunately, will fall on litigators, and we need to convince the judiciary to follow us through. So that's just a beginning. But what I know I am convinced of is that the work is still there and it has to continue. And unfortunately, it falls on us who are in this room to continue with that advocacy because nobody is coming to save us. In terms of implementation of judgments and rulings, I'll give you a good example for Kellen. We sued, actually two examples, the Asero case, which Judge has mentioned, and another one called Patricia Asero, which I can share with you, and which had to do with anti-counterfeit medication, and another decision on a tuberculosis policy. And after that litigation, Kellen took it upon itself to do advocacy and engage with the ministry until we were able to get a repeal of specific provisions of law and the implementation of a TB policy. The learning for us was that after we got the TB policy, like a policy on paper, we were very happy and we thought implementation has ended. But come COVID, we learned that the work should not have stopped at that point. It needs to be continuous engagement. So even as we do strategic litigation, we need to know that strategic litigation is intended to achieve social and policy change. So we don't stop with the win in court. We don't stop with the 1 year, the 2 years. It has to be continued and sustained advocacy to ensure that we're actually reaping the gains that we've had. I know that presents for us a challenge in terms of the kind of funding we receive, but maybe then it's time as an Afrocentric approach to think about the people who we are working with and what sort of support that they're willing to give us. Thank you.
Thank you very much. So in terms of how to handle these neo-colonial actors, of course, once you raise dust, people do not want to be in a dusty place. So name and shame is good. I like it. It's working. But another thing is to create our own scholars, because it's about the narrative. If you read publications following independence of most African states, they're trying to show that these states were going to suffer. They are not prepared, etc. Yes, we suffer, but then we have some form of independence that we are using to lobby and still get a place at the table. I can maybe borrow a leaf from the pandemic treaty. We all know what happened. No one thought that the Global South would come up and say, hell no, we're not going to do that. And I remember approaching some point in the Global South and saying, you can get help from the Global North, but not the countries, but people who are interested in disrupting neocolonialism. And once they agreed with that, they realized it's a good deal. So look for support where it's available and utilize it to tackle the neocolonial actors, because not everyone is comfortable with what history did or where we are going. So in terms of, and that leads me to funding, because why would you be worried about funding? Previously, people were worried about finding funders, but these days, funding follows impact. There's no funder that wants to fund an organization that lacks impact. But if there's an organization that can raise dust, whose publications are superb, you know, they have online presence and stuff like that, everyone will want to be associated with you. So even those few people that have resources that they're willing to use to promote Afrocentrism will be willing to invest in that organization because it's going to create impact. Lastly, with regard to Afrocentrism lacking scholarly articles and stuff, a few years back, whenever you'd put in Afrocentrism, it would lead you to Afrocentrism. But as I speak, when you put it in, there are a good number of publications that have come up. Unfortunately, they are not Ugandan. And I like the fact that Haki put out an advert, dealing with this. So I'm hoping that when that publication comes out, it's going to be a good basis for us to start. And it will create like some sort of positive narratives that we can then build on so that scholars in the future can have an Afrocentric theory that they use as a concept to publish, etc. Thank you so much.
Thank you so much, the panelists. Maybe something that she said about, one of the participants said about building an evidence base is very important. And I think in summary, strategic litigation really has to be strategic. That is, it has to take place over a long period of time. It has to be planned. It has to be consultative. That way it can be as Afrocentric as we want it to be. If we just rush to court, we don't plan very well, we don't prepare for the judges, then things are likely to go wrong. So the evidence that she talked about, the archives, digging deep into us as Africans to find out what used to work, what can work moving forward, and also being aware of the opposition is very critical and very important. So that brings us to the end of our panel. I want you to join me to thank the panelists for their wonderful presentations and also for your participation. Thank you so much, panelists. Much appreciated.
Thank you very much, our first panel. I feel warmth. I don't know whether how you also all feel. I feel a level of warmth. The panel has enabled us to land safely. If it is a flight, it is seamless. We are now clapping our hands. Thank you very, very much. So we are now going to take our tea break, and we're going to have it outside here. The tea break is between now and 12 noon. Please, let's get back at 12 noon because we'd like to continue with the program. And we are running slightly late, but only 15 minutes, which is manageable. We can be able to manage that. Enjoy yourselves. Remember, if you want to take pictures, we have a photo booth outside on the left. The washrooms are down the corridor on your left. Please go to a washroom, depending on how you identify us or how you feel. And let's get here at midday. Thank you very much and have a great tea break. Network, network, network.
if I could use that word. In the case of Uganda, the Ugandans here are aware of the concept of cadre judges. For a very long time, the cadre judges were the minority on the bench. Now they are the majority, either cadre judges or cadre-ish or cadre-like judges, and some of the decisions that are coming from the courts are worrying. So as we look at realizing reproductive justice through litigation, we also need to engage in a very deep conversation on the limitations of litigation, or even question the value addition of litigation. For instance, we always cite these interesting cases. We get excited. When I read cases from Uganda, from other jurisdictions, very good jurisprudence, it excites me. When I see references to international instruments, references to international standards, comparative jurisprudence, etc., groundbreaking case law, it makes one exciting. In my position, I'm a professor of law, so it gives me a field to read and write about those decisions. But do we ever engage in an audit of some sort? Is this good jurisprudence actually making an impact? Where did we start as far as the state of reproductive health is before we started litigating? Has this changed at all? Do we actually link this to litigation? We may have to step out of our, what should I call it, our usual way of doing things as lawyers and begin to draw these linkages. Thank you. I'll leave it at that.
Thank you very much, Professor. Yes. If you have your hand, please, if you see somebody with their hand up, please pass on the microphone. Behind you, there's somebody. Nimrod?
Thank you so much once again. Maybe just picking on from what Professor Mbazira has said. So there are two things that appear to be emerging from the African continent in terms of the litigation and the positive judgments, particularly regarding abortion and reproductive justice. We seem to be making good progress, at least in name. And so I think we need, especially in view of the assault from anti-rights actors, we now need to sort of also hammer the positivity of what's coming from the continent. And it appears that as the United States and maybe some countries in the West sort of retreat from in terms of the judicial branch, we seem to be holding a sort of positive light. And I think it is something that we now need to leverage quite a bit. Yes, we do have issues with implementation, but at least at a normative level, we are making progress. And I think that is something that we have to highlight. The second thing is, again, as Professor Mbazira has mentioned, the Maputo Protocol, the protocol to the African Charter on the Rights of Women, the only human rights instrument which guarantees the right to abortion. And we're the only ones with it. So to what extent are we using it, again, as a sword and as a shield when it comes to reproductive justice, but also holding back anti-rights actors from gaining a foothold on the continent? We were at the African Commission session last year, and to our surprise, we saw a lot of the organizations that are, I'm not going to be politically correct, that are causing havoc on the continent, seeking to be admitted as with observer status at the African Commission. So we need now to also start leveraging on the things that we have only here on the continent to make sure that we consolidate our gains, but also break new ground going forward. Thank you.
Thank you very much for that. I saw, I think, two hands on the table there.
Okay, can I have the mic?
Yeah, please.
Okay, cool. Good morning, everyone. Oh no, good afternoon. Isabel Mwangi is my name. I come from Kenya, working with an organization known as CRU and part of the legal support network in Kenya. I actually just want to pick up from where Nimrod has left it. I think even as we're having this conversation around decolonization of reproductive justice, we must be very cognizant of the gains we are making. They might be small, but they are good gains nonetheless. A very good case in point is a lot of countries actually have a reservation on the same article Nimrod has mentioned, Article 14. Yeah? However, that has not stopped countries from being able to progress with their national laws and actually supersede the needs of what, or the threshold of what is articulated in Maputo Protocol. Kenya being one of them, where we have such progressive laws that have gone beyond the ingredients that are, or what is articulated under Article 14 of Maputo Protocol. But also noting that some of the nuances that exist even in some of these regional legal policies and laws, we still see there's a heavy hand from the piper. We see the nuances that are still very northern global oriented. And so it is for us then to be able to understand how do we unpack this, even when countries do not just sign and not ratify, which is, we now need to start understanding that that is fine, they have read, how then do they then go and contextualize, even without having to ratify this within their own national or legal boundaries in that understanding. And so for me, it's just to be able to say, let's just even appreciate the small gains that are taking place. Thank you.
Thank you very much, Isabel. This side, what is happening? Eh? Okay, we have a hand here and on this table. And then also we have our online participants that are going to comment after.
Sorry, I couldn't say much when I was chairing the panel. It was the panelist time. But I have my own reflections on litigation a bit. And the only one I'm going to touch on is the one around the courts themselves and how we put them at risk through litigation and how that is supposed to be handled. How are we going to frame our arguments better in such a way that we don't put courts at risk? So in an increasingly authoritarian environment, like the one we have in Uganda, I don't know what they have in Kenya and other places, how do you craft litigation in such a way that you don't put your courts at risk? You make your judiciary your friends, and at the same time friends who can give you what you want from them without having them closed down or without them being made more of a kind of judiciary than anything else. That's something we have to think about, that as we plan litigation, let us also plan for the judiciary. The judiciary should be a tool that we support rather than a tool that is that we think has overs the opposition.
Okay.
Like the judge was saying, how do we help them to make better decisions? How do we help them to do their job? I think that's what we should reflect upon as we craft our own litigation strategies. We should think of the judges and the courts and the fact that they should be able to dispense justice tomorrow. Ugandans, you remember the first Nyefuza cases. Those cases were really nice. The judges did a great job. Now down the road, very few judges are willing to stand up and do the right thing. Part of the reason may be because we really milked them quite a lot without supporting them that much. Thank you.
Okay, and as indicated by the Minister of Justice last week, we must safeguard our judiciary and don't involve them in the politicking and all the pulling down we do, especially using social media. Okay.
Thank you so much. Just in the spirit of small gains and just to add on to what Nimrod had earlier mentioned, speaking about like strategies, at Haki we did identify some of these strategies and we sort of documented some of these strategies which we know that we would elaborate on in the long run. At least one of the strategies, for example, we do know that national courts in various jurisdictions have issued various judgments that have moved away from broad reproductive rights arguments. The PAK case in Kenya, for example, is one, and the Christian Lawyers Association case in South Africa, for example, is also another one. So as litigants, one strategy would be to compile these positive precedents and employ them strategically to restrict the judiciary's ability to adopt perspectives that are aligned with the opposition. Thank you.
Thank you very much. Any other reflections we have here? There are two tables that I do not know what is happening. That table and the last table, and this one here. Hey.
Thank you very much. I think the role of the judiciary continues to be a major issue of focus. And when you think about the legal systems that we have, and as the Honorable Justice said last week, the judges fold their hands and they wait for issues to be brought to them in our common law systems. They never invite themselves in spaces where they have not been invited. So I keep wondering how far we can stretch the concept of judicial activism. In a colonial setup where a judge is supposed to wait for issues to come to them to be handled. So this whole concept of judicial activism, and I would really want to hear from the judges, what have been their experiences and how have they dealt with it to be able to deal with the sophisticated, complicated issues of reproductive justice. Thank you very much.
Thank you. We have on this table, and then, yes, sure.
I can go ahead. I think the role of the judiciary is really quite critical in gating the gains of strategic impact litigation. I would want to step back and reflect from contextual experience from my own country. Strategic impact litigation in itself is not viewed from a positive stance from the perspective of the judiciary. Every other instance of strategic impact litigation has been politicized from a perspective that human rights discourse, never mind you talking of reproductive justice, you're talking of civil and political rights, has been heavily politicized, such that often when you approach the courts, you are frowned upon. Why? Because you're seeking to sue the government. So in my own jurisdiction, the issue of strategic impact litigation as a means of social change has not really been a very critical tool. Often you approach the courts, they hear your case, they reserve the judgments for eternity. For instance, in my organization, we litigated, the hearing was on the 2nd of February. Up to the date, we haven't received the judgment. Sometimes they deliver a judgment without reasons. So in as much as you want to talk of jurisprudence, how then do you get a meaningful jurisprudence which is clarified on points of law, which has created a precedent when the judiciary itself is not a willing player? So sorry to take longer, but I've noted something very critical and very important, the role that the Law Society of Uganda is playing, probably as a neutral player. I want to ask probably the Law Society of Uganda, maybe what they have done, if this is if they do have a similar problem in Uganda, what sort of interventions or what sort of mechanisms have they put in place to ensure that the judiciary itself appreciates the importance of strategic impact litigation? What sort of lessons can we learn? In my own country, the Law Society is not as actively involved as what I've seen here. So I'm very keen to know and to note what we can take out of this. Thank you.
Thank you very much. Can you please tell us your country and your name?
Okay, I'm from Zimbabwe. My name is a little bit problematic in pronunciation. Well, I was just saying probably I could pick an English name, just random.
No, own your name. Own your identity.
Okay, all right. My name is Ishe Anesu. It's a vernacular name. It means the Lord is with us. Yes. So you can call me Anesu. Yes.
Thank you very much, Anesu. And please, let's make sure we speak in the microphone, we speak slower, and that we don't use jargon so that we can ensure we have a more accurate translation.
Yes, good afternoon, everyone. My name is Dr. Herbert Ruswata, the President, Uganda Medical Association. Apologies, I came a bit late because I was late somewhere and I missed, I think, a panel discussion in the morning. But I want to first thank Sehad or Haki for inviting the practitioners to take part in these discussions. Most of the time we have been meeting with lawyers in courts of law when we are being summoned for mismanaging mothers. Sometimes when we are being blamed and being, accused of killing mothers because of, systemic challenges. There are a number of cases we used to get at Uganda Medical Dental Practitioners Council where, doctors and other health workers are really being summoned. And when they go deep into the discussions, realize that sure, health workers have no issues, but the system is causing a lot of problems. And sometimes cases, even in court during discussions, they learn that there are systemic problems which need to be changed and worked on. And I'm glad that now the advocacy is not only focusing on health workers, but also putting government at the spot and trying to advocate and make sure the government does what it's supposed to do. And I would like to appreciate some of the things which have really come out of this, kind of activism and litigation. And one of them is sure to help to improve the maternal care and make our practice easier. Today, we have specialists or gynecologists who are being deployed in the district hospitals or general hospitals. We never used to have them, and mothers used to suffer traveling long distances when they used to have complications which needed specialized care. Last year we had a meeting with the president, and we wanted doctors to be deployed at a sub-county level because a lot of maternal mortality cases were coming from the lower facilities at Health Center 3, and using the argument of this need for better health care, mostly for the mothers. The president accepted, and this year in May, a new public service structure was released. And the government has accepted that we need doctors at every sub-county levels, at least 2 of them. And this is really a positive thing for us. Today when you go to
we need to clap about that. Eh? Or we are still paralyzed, we don't believe that it is true. Okay, let's clap at least for that.
When you visit most of the facilities, most of government facilities, actually even in the private, whenever there is a maternal death or early neonatal death, you must audit that death within at least 24 hours. And you must notify within a given period of time. And that one has also put us, made us alert as health workers. You want to know, why did I lose this mother? And if you're a doctor and you are leading the team, you should lead that death audit. And then you know where I had the problem. And it helps us that every day you discover new challenges. And then you become innovative and find solutions. And the next day you realize that the number of mothers you are losing keeps on reducing. There's a new innovation also in regional referral hospitals where there's mentorship programs. Many regional referral hospitals receive many referrals, and sometimes mothers die on arrival at health facilities. But sometimes when you do a background check and all that, you realize that these were preventable deaths, and maybe these mothers could even be managed at lower facilities like the center for all the district hospitals. And then you wonder why they were referred and then died because they delayed to receive care. And when these small issues are found out, and maybe you realize that there is lack of competencies at the lower facilities. The regional referral hospitals have come up with a model that you go down to those lower facilities and you give them mentorship, or you give them skills or empower them. Sometimes you can even deploy healthcare personnel from lower facilities to regional referral hospitals for a month or for weeks, and then you give them those competences they are lacking. And this is really improving maternal health care in Uganda. I just wanted to share that and to thank Sehad and other lawyers who have taken part in this kind of advocacy. Thank you so much.
Thank you very much. Pass on the microphone to PPG.
Yes, good afternoon, everyone. Baksh Asman is my name, and I'm going to speak from the advocacy point of view. One of the reasons why we do litigation is to support on the advocacy work we do. Recently, we're having conversations when we're having a case conceptualization process. And there was a lot of sentiments around the different jurisprudences we are going to make. If we make a jurisprudence and it is negative, literally 3/4 of the room was saying that is going to affect our advocacy. But one of the things that I was thinking is, one of the reasons why we are going to court is either you're going to receive a positive or negative. How are we going to translate these different jurisprudences into positive advocacy work? I feel there's still a fear to create new jurisprudences. We keep on wanting to, referring to already so many other existing. Yet for a matter of fact, when you look at most of the reproductive health, even in our region, we have so much limited cases that speak to that. And most of them, we have to borrow from outside the Africa region to speak to the different cases. And yet sometimes they might not really be contextual to the issues that we are really working with, which also makes the advocacy work really so hard. So I don't know how we are going to ensure that we foster the conversation. And we're speaking with Nyokabi here and say maybe the conversation should move to have as much jurisprudences as possible, whether they are negative or positive, but prepare ourselves for more, even though we get negative ones, how do we prepare ourselves to transform those into positive advocacy strategies? Thank you.
Thank you very much. We had a hand here, and yes, there's a microphone there.
Yes. Hi, I'm Melissa from Mexico, and I would just like to share like a couple of things that resonated with me with what I've been hearing from my colleagues. First of all, I wanted to share that in Mexico we had something called Solicitud de Ejercicio de Facultad de Atracción, which translates basically to attraction request, which is one of the ways in which the judiciary has been more involved in cases of a strategic litigation, in which, for example, civil society can bring up a case and the justices can decide whether they will attract that case or not based on importance and transcendence of the basis of the constitutional trials. So that has been a really good way for the civil society to bring up cases to the Supreme Court. I will elaborate a little bit more about that in tomorrow. But I just wanted to let you know that there are certain ways in which the judiciary can also be more active and translate this into rulings that can change the lives of women and pregnant persons. And in addition, currently in Mexico, we're facing a really hard situation in which the judiciary is being well, it's in the middle of the political hurricane. For example, there's a proposal of reform in which the president is trying to eliminate all of the justices and all of the judges in order for them to be elected by popular vote. And one of the reasons is because, well, the justices have made certain decisions that have angered the executive. But what we have learned about all of this situation is that the judiciary has to be more active, and that they also need to translate their rulings to the common people. Because sometimes we as lawyers understand what the justices are saying, but the people don't understand how their rulings translate into their lives. And one of the ways of the judiciary of protecting themselves as well is by translating their rulings into normal language. I mean, in Mexico, we have like this saying of abogañol, which is basically like lawyerese, like this special language that we lawyers commonly use. And we have seen that that is a barrier for not only access to justice, but as well for the judiciary to protect itself from these attacks from the executive, for example.
Thank you very much. And your submission has tried to answer some of the questions that were raised by Dr. Mulumba and the reservations or concerns that were raised by Dr. Juko, as well as feeding into the challenge were given by Her Lordship, Eva Luswata. I saw another hand around the table there.
Thank you. My name is Analia. I'm from Rios, and I'm originally from Uruguay, and I work in Rios. It's a regional organization in Latin America that supports local organizations in their efforts in legal actions regarding reproductive justice. I'm going back to the first remark in that table. I think it was about the limitations of litigation. I think that's a very important one. And because good jurisprudence by itself is not enough, right? We can have a very strong and solid decision, but the big challenge, both in Africa and the Americas, is implementation, right? So I think that we should have always in mind that after litigation, we need to have two strategies. One is for implementation, so policy is very important, of course. And the other is be prepared to defend the framework. Because the attacks will come and they will come stronger than ever. And in Latin America, we have very good examples about this. And regarding this strategy, something that has worked in some contexts in Latin America is to, and I think in that table you raised that aspect, is to approach the judiciary, is to approach policymakers and have allies within the government. That is fundamental. And we had some good experiences in approaching the judiciary with, we noticed that what they in general, they like to these peer-to-peer conversations. So instead of us going to the judges, they won't listen to us. So we bring judges from other high courts of the Global South to talk to them, like in a peer-to-peer conversation. And that is more welcoming in general than civil society or local academia approaching them. This has worked in some contexts. The second thing I wanted to highlight is the very strong, the link between sexual and reproductive rights and democracy, like human rights and democracy. So, and we should have a broader perspective and dialogue outside of the feminist movement with other movements, right? And we can see, for example, in Argentina, where now democracy is very fragile, and all the gains, the huge gains in the previous administrations are in basically, it's falling. I don't want to be pessimistic, but then when we live in fragile democracies, we should look at the broader context. And last, I'm curious about how the legal opposition works in Africa. And my specific question is, have there been any attempts to modify the constitution? The constitutions, for example, I'm thinking about Honduras, which is a country where there is a total abortion ban, one of the 5 countries in Latin America. And when there were some attempts to modify the criminal code, to have some exceptions, it didn't work. So when the anti-rat movement saw that there were some efforts to change rights to the criminal code, what they did, they were very smart and very quick to, they amended the constitution to expressly prohibit abortion at the constitutional level, right? I don't know if there were any attempts in Africa with that kind of a strategy from the opposition, and if there weren't, I should be very aware of it. You should be very aware of it, because that's when they see that civil society or the academia is trying to modify the criminal code, they will try to amend the constitution so that won't happen. That is how they have tried to, and they are, of course, sometimes we are behind their strategy. So just wondering if that is a strategy of the anti-red movement in Africa. And that's all. Thank you.
Thank you very much for sharing your experiences, but also for trying to answer questions that were raised by Professor Mbazira. We had a hand here, and then we'll move to Honorable Commissioner.
Good afternoon. Kanyisa Mapipa from South Africa. I wanted to just ask if there has been any attempt or thought about bringing in healthcare workers into this kind of discussion and this kind of forum, particularly because that's a problem that we have in South Africa. The biggest opposition comes from our healthcare workers. It also is a issue of stigma that comes from communities, works its way into our healthcare facilities, works its way into our political structures, and obviously into the judiciary. And I wonder if addressing it at that level might be something that would be worthwhile, particularly in this kind of environment. Abortion, for example, is legal in South Africa. It's even enshrined in our constitution. But our problem is access. So there is very little implementation of that. It's a limited right. It's limited to available resources. And so obviously the way to do away with it would be not to give resources to the right. And so that's what we've seen. And that is a direct result of the stigma that is associated with it. We see that stigma operating quite a bit with minors who seek contraceptive care, minors who seek access to sexual reproductive rights, whether it's abortion or other sexual reproductive rights. And in a country that has a high level of gender-based violence, particularly against minors, we really can't afford to have that kind of stigma fermenting and growing. And so I think, so we've at least tried, in the organization that I've worked for, to speak to healthcare workers, to try and bring them to the party. But a lot of the time, the stigma stems from personal beliefs. It stems from putting themselves in perhaps the parents' shoes, seeking that, that if a minor, for example, comes to request contraceptives, that they must come with a parent, which is things that are not legally required. And so I wonder if perhaps the medical community, perhaps we can't find allies in healthcare workers in doing this work, so that it's not just pressure coming from civil society, but it's also pressure coming from members of the medical community, because it is such an important thing, even when it comes to the realization of other health rights for women and members of their communities.
Thank you very much. For that particular question, I'd like to request later on sharing of experiences from the Medical Support Network Kenya, Legal Support Network Uganda, and the Obstetricians and Gynecologists of the Medical Association of Uganda, if there's any experience to share.
Well, thank you. What I wanted to bring to the fore is the fact that, yes, indeed, the judiciary has got a part to play in reproductive justice litigation. But I think we should be mindful of the fact that the judiciary, especially like where I come from, or maybe the ones where which rely on the common law type of law, have to wait for cases to be brought before the judiciary. The judiciary cannot move itself to deal with these particular issues. So it behoves upon lawyers to bring up cases before the judiciary. And the point that I want to drive home is that in terms of preparation of those particular cases which are brought before the judiciary, the pleadings which are filed must be done in such a manner that they really raise the issues which require the court to decide. it goes without saying that, well, in my jurisdiction, these days we even file our arguments in advance. So those arguments which are being filed should be arguments which have been properly researched. In certain instances, as speaking as a judge, I've come to realize that some of the cases which are being brought before the courts are not properly prepared by the lawyers that are representing. And in some of the instances, you'll find that it's actually individuals who are acting in person who take up those particular matters. And for them to navigate through the legal process, it becomes a problem. So it's a presentation of the cases that also determines how the court is going to decide. And then we are talking about reproductive justice, litigation, and stuff like that. Here we are dealing with the emerging issues. These issues never used to be there before, and some of the judges might find that this is a strange topic in inverted commas. So my point will be that at events like this, it will also be necessary that we also invited a number of judges to be present, not only as resource persons, but also as participants, so that they can learn about these particular issues. Thank you.
Thank you very much. We have a last comment there, and then we can go to the online participants. Tech team, please prepare. They are coming in next. It's here, Dr. Igogo, because there were questions about what learnings, what has been done elsewhere to bring law and health together.
Thank you very much. My name is Dr. Peter Igogo. I'm an obstetrician gynecologist from Nairobi, Kenya. I'm also a lecturer at the local medical school. Thank you for that comment and that challenge from South Africa. And what we have realized, and it came out yesterday, even from yesterday, there's a lot of influence from evangelicals at our medical schools. When the medical students report the first few months, there's a lot of indoctrination about Christianity, family values, and that actually, it's a big challenge to us when it comes to sexual reproductive health. Actually, there's a discussion in one of the medical schools that should we now replace the word abortion with miscarriage? Some people are not comfortable with the word abortion, and we know it's a medical term, and it's a problem. In one of the public facilities that I practice with my students, when you get a maternal mortality from unsafe abortion, it's never given the same weight as maternal mortality from other causes. So that challenge has been there, but as doctors, as advocates for women's rights and health, we have come together to form what we call Medical Support Network. This is a group of doctors who are advocating for maternal health. We are spread all over the country in Kenya, and we are out there to advocate for women's health. And we are actually sensitizing even the other doctors on matters sexual reproductive health, and this has a great impact. Challenges have been there because we developed standard and guidelines. They were instated, but that thing has not been, it has not percolated well in the community. Still, providers are not aware that they can be trained on provision of safe abortion services. We have students who are graduating, and the other day they were asking me because the issue of comprehensive abortion care was removed from the curriculum. They are no longer trained even on post-abortal care services. So we have them graduating, they don't have the skills. So it's a big gap, but we have come together as Medical Support Network to bring the voices of these women, because we all know that it's a public health problem. It's one of the leading causes of maternal mortality. Thank you.
Thank you very much. I'll ask Dr. Herbert Luswata to come in also from the Uganda Medical Association. Can we please get a microphone there?
Yes, thank you so much. I just add something small on what I said. Concerning the law, where we have been having trouble as practitioners is mainly an area of abortion. One of the biggest killers of mothers in Uganda today, in our area of obstetrics and gynecology, has been unsafe abortion, which is at around 13%. In Uganda, we still have a few issues concerning access to family planning services in remote areas and to the youth. And this has resulted to many unwanted pregnancies in Uganda. Now, in our practice, many times we are being approached by parents who come with their children who are in secondary school, even in primary school. We've got issues of even older people who have come to us and they are requesting to get abortion or safe abortion services. But most of the time, because of the law in Uganda, we turn them away. So they end up going to to other people who are not really professional. They have done lots of things, and then they come back with complications. Sometimes, because now when they come with the complications, now we are allowed to salvage their lives. Now that's when you come in, but usually come in at a later stage, when a lot of things have happened and they end up losing some of these mothers. However, there are a few instances where surely doctors have done these abortions with medical reasons, and they have ended up at the council or even in the courts of law, and some of them have surely been convicted, which is a problem. But again, when sometimes mothers reach late, they have bled a lot, you look for blood to give them blood transfusion and you don't get it. Again, at the same time, when you lose such mothers, you are also summoned to court and say that you didn't do your things in time, and the doctors have ended up in problems. I don't know, I know we have a government maybe which does not really support abortion and our religions, but I think we need to just allow these people this right. If my daughter is in P7 and she has messed up and she's pregnant and I need her to continue to go to school, they should be allowed to have safe abortion. Even adults, if they have unwanted pregnancies, they should be allowed to abort. I know in a number of instances we have had, the law allows us, if there's any medical condition or if this pregnancy compromises the life of the mother, then we are allowed to do it. But because we are avoiding these mothers coming to us with complications, some people have really manufactured this kind of situation and then just try the abortions and they have done it. This is the reality on the ground. And some people will tell you that I would rather help them now and I save their lives than coming back to me in the night at 2 when I'm sleeping and I can't help them and they die in our hands. I think if this law is sorted and the conflict between the government and the courts and the practitioners, and we have a clear law on this abortion thing, it would be a very good step in reducing on the maternal mortality in Uganda. And I think we need you, the lawyers, since this is your area, to push for this. Thank you so much.
Thank you very much. We'll now go to the online participants. Online. And as we're going into the online participants, I'd like to request you to speak at lunch. Make sure you sit with the neighbor that is behind you. Look at each other. Yes, the two of you, because you have to explain how the law, the lawyers, and the healthcare providers are working on that under the Legal Support Network in Uganda. And she has accepted to have that conversation with you. Are we ready for the online participants?
Yes. Can you hear me?
Please introduce yourself, your country, or where you're listening in from, and then your question or comment.
All right. Good afternoon. I just want to confirm I can be heard.
You're loud and clear.
All right. Thank you. My name is Emily Butime. I am a Ugandan lawyer, presently living in Kenya, Nairobi, Kenya, and practicing in Nairobi, Kenya. In the little known area of family advocacy, and I work with an organization called Program for Family Development. And I just want to comment and also make a question. I had thought that I would be given an opportunity earlier, but I will try and merge both comments. One of the previous panelists mentioned the Geneva Consensus Declaration, and the light in which she mentioned it as a neo-colonial influencing tool that is anti-women's rights, and arguably that has been one of the things that has come up as out of that declaration. However, that same declaration is also a declaration that comes out to protect the family. And I bring this in relation to the theme, an Afrocentric approach to litigating reproductive justice. If we consider that document as purely anti-reproductive, in the sense that it affirms, or rather it emphasizes that abortion is not going to be used as a family planning tool, we turn a blind eye to the other end that protects the family as a basic unit of society. Now, I could be wrong, but this is a strongly Afrocentric approach, the idea of family and protection of family. One of the backgrounds of this declaration is, of course, the awareness that, which is not happening in the South, is the awareness that there is a detachment between the role of parents and children in determining whether an abortion should take place or not. It is now, enforceable law in the US, in the UK, and several other European countries that a minor can go to a medical facility and receive abortion support services without the knowledge or approval even of the parents. So those are some of the backgrounds to this document. Now, how do we consider this Afrocentric? One of the things we know as Afrocentric is the strength of the family. Now, my question is, should we consider the protection of family as necessarily anti-women rights? Because that appears to me as a clash of ideas and a clash of realities. If we talk Afrocentric, we need to accept and admit the realities of the African culture. And I am cognizant of the fact that Professor Chinyinjisha mentioned that we don't have one unity of culture in Uganda or even in Africa, but we do have certain ideas and certain concepts that are across all countries in Africa. And one of these is strength of family. I said this cognizant of the fact that Uganda is a co-sponsor to the Geneva Consensus Declaration, especially the ideals of protection of family. So my question to that, and in connection to...
Can you please summarize? There is a number of people that would like to...
Yes, I'm finishing. My question is, how then can we, towards achieving, a justice and having a judiciary cognizant of the fact that this is an Afrocentric idea, the protection of family, and together with the idea that Justice Luswata mentioned, constitutional morality, how do we merge this? Because we have the medical practitioners talking about the family idea, and then we have the idea that the protection of family might be anti-women. Where do we form a middle ground? That's my question. And how does this guide the judiciary? Thank you.
Thank you very much, Emily. We have also others that have sent in chats. As we're trying to maneuver through, I can be able to read those chats. We have from Permission to Exist in Eswatini, who is loving the conversation, as well as from Tanzania. We also have a message that is coming in from Liberia, from Nadine, and Malawi. And then also a question that is coming in from Rashid Imoro from Ghana, in terms of how do we overcome misunderstanding about sexuality education. And then others are all greetings that are very warm, all the way from Uganda, from Zimbabwe, South Africa, and Malawi. Do we have any other comments on the online?
Yes.
Please proceed.
Augustine Richard Kaketo, Pulmonary and Company Advocates, Nairobi, Kenya. It's a great conversation going on here. I realize that Africa is notoriously in favor of human life. The challenge I'm putting out to the professors in the hall, philosophically, how would we reconcile the conflict between the protection of human life from conception and the woman's right to choose whether to keep the baby or not? Thank you.
Thank you very much. So do we have some of us that would like to respond? We have two questions that are coming in online, at least the ones we had in the room. We had a conversation. There's a question that came in from Emily and another one that has just come in from Kaketo, from Nairobi. Any response that we can have from the room, from the panelists? Yes, please. Can we please bring the microphone here? Let's take the microphone to
I will provide a fairly limited response because some of the greatest thinkers on how family is used, the rights of family are used to deprive individuals around sexual orientation and gender identity, around gender-based violence, about education, right to knowledge, right to speech, are in this room and can speak with great eloquence about how when rights conflict, we sort of navigate that in law and also in society. But I specific to the Geneva Consensus Declaration, I just want to reinforce that it is not a consensus and it was not drafted by any of the people in this room or your elected representatives. It doesn't come out of negotiations between our governments. It is drafted in Washington, D.C. by single people who have a very specific definition of family, and that's a definition intended to exclude many people from the rights of accessing law and protection. It is a very specific, very white, very American, and very Christian definition of family that they seek to enshrine in law for protective value. So there is no conflict between women's rights and the rights of the family, but I urge, when we are thinking about neocolonialism, to define family and family rights under the law in our legal systems, not in Washington, D.C.
We have a hand there. Thank you very, very much. Please take out you English speakers, this is now the end of your privilege. Please switch into channel. English is channel 1, Spanish is channel 2.
Buenas tardes, mi nombre es Soledad Esa, soy de Argentina. Y me parece importante para responder a esa pregunta que tiene que ver con un dilema moral y cómo se compatibiliza el derecho en términos morales y éticos, tener presentes que el derecho a la vida es interdependiente con el derecho a la salud y a la dignidad. Solemos pensar la dignidad como intrínseca a la vida de las personas y en virtud de algún tipo de creencias o de algún tipo de religiones, extrapolamos o transferimos el valor o ponemos en lugares equiparables el valor de la vida humana respecto de la vida intrauterina. Este posicionamiento, que es moral, que es ético y es religioso, no es cuestionable siempre y cuando se mantenga en el fuero interno. Ahora, un proveedor de salud tiene que ser respetuoso de la dignidad de su paciente, tiene que ser respetuoso de la autonomía y tiene que evitar la maleficencia como aquella obligación médica que impide provocar un daño. Si nosotros, o si un proveedor de salud no traslada este dilema moral y ético que es personal al campo de la atención sanitaria, lo que va a hacer es arrasar o violar la autonomía de esa persona. También me parece importante pensar que la libertad de conciencia está garantizada en la Carta Africana de Derechos, y la libertad de conciencia protege tanto la libertad de profesar cualquiera de los cultos como de no profesar ninguno. Entonces, dotar de contenido religioso a un dilema moral que es personal y trasladarlo a la atención sanitaria violaría además el derecho a la libertad de conciencia de la paciente. Hago esta aclaración porque solemos pensar frente a una demanda de aborto que la paciente no tiene conciencia o no tiene ética. Y en realidad puede tener una decisión ética, una decisión de conciencia que no sea o que no sea compartida con la del profesional. Pero la asimetría propia de la relación sanitaria le exige al personal de salud mayores esfuerzos para cerrar la brecha de desigualdad. Solemos pensar también en violencia y en desigualdad de género como un enfoque interseccional aplicable a la atención sanitaria, pero nos desentendemos de la asimetría de poder que supone el personal de salud como sujeto supuesto de saber, capaz de subtitular a la paciente, capaz de arrasar su conciencia y en ese comportamiento violar las propias obligaciones éticas y legales. Entonces, la protección de la vida intrauterina o la obligación de protección de la vida intrauterina desaparece al momento en el que se exige un aborto permitido por la ley. O sea, ese dilema moral no existe cuando la legalidad del aborto surge del marco normativo. Pero también podríamos pensar, yo voy a hablar sobre eso mañana, también podríamos pensar que más allá del marco normativo puntual, las obligaciones éticas y morales respecto del respeto de la autonomía existen para todo el personal de salud por sobre la protección de la vida intrauterina.
Thank you very much. A small comment from your neighbor, and then we wind up this session.
Thank you. Just adding to what Soledad was saying, that it's also useful to argue that the state has another ways to protect the life of fetuses of intrauterine life, such as policies to accompany and support women who desire to have family, to desire to continue that pregnancy, with a lot of different ways and policies that are not invading, that might not invade women's autonomy. So that's another way to kind of get away of that dilemma by stating that there are other ways that do not affect human dignity, women's dignity, and in which the state can also protect that life. So it's a way of just avoiding the conflict of rights dilemma, and but without denying it, just using another ways that the law has and our policies has to combine both without basically violating women's rights.
Okay, thank you very much. I'd like to allow me to bring this to a close. It's not the close of the Baraza, but like we know, the sessions, one is feeding into another. But also it is a conversation. It is a Baraza. We are learning from each other. We are sharing. We are surfacing questions. Some of these will be answered. Others will not be answered, but we are still journeying. As we are trying to wind up this session, I'd like to acknowledge and recognize within our midst some of us that really are holding space in key strategic places. I'd like to begin with the justices that are here, the Honorable Justices. Honorable Justice Susan Okalanyi, Judge of the High Court of Uganda. Then we have Honorable Justice Mandala Mambulosa, Judge of the High Court of Malawi. Then also we have Professor Christopher Mbazira, Professor of the School of Law, Makerere University. We also have our own Professor Ben Twinomugisha, Professor of the School of Law of Makerere University. We have Laura Nyirikindi, Chair of the Working Group on Discrimination Against Women and Girls of the United Nations Human Rights Council. We also have Dr. Herbert Luswata, President of the Uganda Medical Association. Then we have a number of us that are really anchoring spaces where a lot of the work is done around litigation, advocacy, service provision, and also allowing these conversations to continue happening. We have executive directors that have not delegated but are here in person, that are heading particular organizations. We have Frida Mutesi from Ubuntu Law. We have Professor Oyelenkwel, Director of CHELD in Nigeria. We have Aid Goresi, Director CCD, Latin America. We have Nur Nachibuka, Deputy Executive Director of SEHAD Uganda. We have our own band, she just spoke. Snyder of Preclusion, Senior Project Director of Preclusion Project in the USA. We have Dr. Godfrey Kanyange, Executive Director, Nyange Institute, South Africa. We have Counsel Kenneth Sebabi, Executive Director, Spring Public Interest Uganda Litigation Hub. We also have Giovanna Rios, Executive Director of Women's Link. We had Dr. Adrian Juko, who's just stepped out, the Executive Director of Human Rights Awareness and Promotion Forum in Uganda. And then we have Ineshu. She told us her name was difficult, Anesu, but it's not difficult. That's the beauty of African names. Somebody has to have a conversation. What does the name mean? And that's part of Afrocentrism, reclaiming ourselves. Is the Executive Director of WILSA in Zimbabwe. Then we have Betty Balisalamu, Executive Director of Women with a Mission in Uganda. And then Dr. Herbert Luswata, President of the Uganda Medical Association. And I'll keep announcing us as we are progressing. So, as we end the first morning, which has been very productive, we're going to have a group picture. And after the group picture, we're going to have our lunch at 1:30 and come back here at 2:30. Please make sure that you get a lunch coupon from the Secretariat team. As you go out, please pick your lunch coupon. If you do not pick it, you're going to have to come back to pick it because it's required by the hotel for their own accountabilities and making sure that they serve us the meal that they prepared for us. So we're going to have a group picture outside there at the photo or here. Okay, can we have the tech team tell us where the picture is going to be? And for the online participants, please take a health break. It's been a very long morning. And join us again at 2:30 Uganda time or East African Standard Time. Thank you very much and see you then. So we are going to have the group picture here. Let's have the picture and then go and have our lunch and enjoy ourselves. Please remember to network. This is a Baraza. Remember to network with people that said something you like or a challenge, or so you have an alternate view. It is okay to disagree. From contestation comes new ideas. Thank you. as the birth partner, because we're not sure that after that demonstration, we're not going to have a baby and call the baby Demonstration Kampala. So welcome Noor, our panelist, our moderator, who is going to take us through the panel. You're welcome, Noor.
Thank you so much, Salome. That baby has since become Petition 16. And I think that is, and Petition 16 is the famous maternal health case. So I think that's how far we go with advocacy. That sometimes you need to get into the real activism. So we really want to appreciate you for the morning discussions. And we should be now moving into the courtroom to see conversations that happen in court. The team that was here yesterday, we had a conversation around abortion laws and policies in selected African countries. And we noted that countries like Uganda, actually all countries were colonized. We looked at Kenya, we looked at Uganda, we looked at Ethiopia, among other countries, South Africa. And we noted that countries are running away from archaic legislations to amending them, and the ministries of health are being proactive to even push for guidelines on reproductive justice. And I think it's time that we see how the lawyers are doing it. And in this way, we'll then have a conversation this afternoon about the state of reproductive justice, really discussing cases from countries in Africa, including Uganda, Malawi, Zimbabwe, Kenya, and South Africa. So allow me to invite Betty Badisalamu, who is the Executive Director of an organization that is based in Mbale, that is called Women with a Mission. Mbale is a district in Uganda. We want to welcome her. One of those people that is in the districts in Uganda doing a lot of work there, so that we listen into what they are doing. I'd also love to take the honor to invite Michael Kayasa, the Executive Director of Center for Human Rights and Rehabilitation, who will also speak to us about the conversations that are happening in the other country. We'll invite Kirisa Anesu, the Executive Director of Women and Law in South Africa. We are speaking to only executive directors. I have taken note of that. Executive Director of Women and Law in Southern Africa, we are honored to have you to speak to us today. And we'll speak to Khanyisa Mapipa, the Head of Health Programs, Section 27 in South Africa. And we all know that South Africa has progressed when it comes to conversations around abortion. I think one of those very progressive countries when we look at laws. But we'll hear from them on how the law translates into access to the services themselves. And lastly, to the only health service provider that will speak to us today, who is Dr. Peter Igogo, that is an OBS and GYN expert from the Medical Support Network of Kenya. So I will take the honor to have a series of questions to the panelists today. And Uganda being a host, we can only allow Betty to start us off. So I indicated earlier that Betty works with Women with a Mission. And we want to hear from Betty today to kind of expound to us the litigations happening at the community level. When I speak about community level, I mean subnational level in Uganda. And we know that in the communities away from Kampala, cases of abortion happen. So much more because access is kind of a challenge. So I want to hear from Betty how you really identify these cases. How do you identify them? How do you assess them? How do you determine that this is the case that I want to go to for this particular matter? And perhaps what has been the result of the litigation that you take on. For the panelists, we'll just take about 5-10 minutes to have a conversation because we really want to get back to the online team, but also the team in the room to hear if they have any questions with us or experiences that we can share as part of learning. Over to you, Betty. Thank you.
Thank you so much, Noor. Like Noor has said, I'm here to represent the rural woman. I'm here to represent a market woman. I'm here to represent a sex worker. I'm here to represent an LBQ woman. So I'm here to represent inclusivity, diversity, but also in terms of community level. When you talk about litigation or reproductive justice, you can't leave out the community aspect. And I'll begin from here in terms of what is reproductive justice, and I'll connect how we've been able to provide rapid response to our communities. When you talk about reproductive justice, it includes the right to make informed decisions about our reproduction, parenting and family life free from discrimination, coercion, and violence. It often includes access to contraception, reproductive health services, including family planning services, parental care, abortion. And I was there thinking, does this most times apply to a rural woman? Most of the time, this doesn't apply. Some of these are actually in terms of like books, or they are just narratives that some of the women just hear about. Because we have seen instances, so many instances. The recent one where I think it was on NBS or TV, and on NTV, where one of the ladies in communities of Busia was assaulted by the husband because she had enrolled on family planning. We have received so many cases in the past 1 month. We have received so many cases of maternal mortality due to unsafe abortion. So in terms of what have we been able to do around litigating reproductive justice, as we are aware that whereas we have some aspect where a health worker can be able to provide abortion, most of these law enforcers are not aware that there is that open window, and most of the time health workers have been arrested. I'll give a live example. As a community member, I like to bring example. One of the health workers in one of the renowned clinic that I will not mention helped a dying woman was brought to her with a stick inserted in her uterus because they had failed to remove, she had inserted it, they failed to remove it, and they brought her to this particular clinic. And of course, this is a post-abortion care. And what happens? Because this is a health worker, and of course the Ministry of Health talks about it, that we are supposed to provide PAC because we are saving the life of a woman. And what happens? After this doctor helping, we were called that this particular doctor had been arrested. And during the time of arrest, there is no right to a lawyer. They were just picked from a health facility while they were actually about to enter the operating room to help another woman who had been brought on a margin of life and death. So what happened is we had to go and intervene to make sure that this health worker actually comes out. But even that wasn't easy because even at that moment, just whereas they say police bond is free, it is actually paid for. You can imagine at the police level, even at the state attorney's level, they had to get money from this person. You know, at that time when you as the lawyers, you're trying to ensure that bond is not for free, but you remember the health worker or this particular person is thinking about their freedom. So as lawyers, as community members under the LEADER program, we have used the reactionary approach in terms of providing legal legal rapid response to most of these health workers. We can say that during the RELAP program, we have actually been able to react to around 17 cases of health workers that have been arrested because they were caught procuring not even a safe abortion, but PAC. Yeah.
Right, thank you so much, Betty. I think Betty clearly indicates that they have made a name at the community level that calls will always come in. We only missed a bit of do you proceed to court? Why we ask this question is because my experience over the 15 years has been that cases of abortion will be known, cases of abortion in the media, community and all that. But the impact of getting the real evidence to move to court right from the community, is this a thing that happens in Mbale? Do you want to draw us there? Or are they cases that you get to the level of police as they investigate together with the resident state attorneys, they actually realize there's no evidence and only have to pull out? How is it in Mbale?
Yeah, thank you for that. Usually what happens as the legal rapid response team, we don't usually want these cases to jump beyond police level, because it is so much traumatizing for such a health worker who is actually intending to save life. But also in terms of evidence, most of the time that these cases that are actually brought to police lack evidence. And even when they proceed to court, most of these cases don't reach the level of like decisions by judicial officers. So what happens is we make sure that even when the person is brought to police, we make sure that they are either released free of charge or they actually get police bond. And when police, of course, fails to get evidence, they are finally relieved of. But also when some of these cases reach court, we make sure that because of lack of evidence, these cases are dismissed. Thank you.
Thank you so much. Let's go to Zimbabwe. I know, Anesu, that you have a case in court. Let's hear from you. What has been your experience litigating this case? And what, in your view, could be the likely impact? Is the law allowing you to even litigate? Over to you, Anesu.
Okay. Thank you, Director of Ceremony. Thank you again for pronouncing my name correctly this time around. Yeah. Probably just to step a little bit back and give context of my country in as far as strategic impact litigation is concerned. In 2013, the country enacted a new constitution. We still call it the new constitution, never mind 10 years. Yes, yes. But it's arguably a very good constitution on paper. Why? Because it really has a very expansive Bill of Rights. It also has tried to open up access to justice through what we term public interest litigation, through strategic impact litigation. But unfortunately, between the constitution and the practice, there has been a very huge gap. The experience has been that when you approach the superior courts, which is the High Court, Supreme Court, and the Constitutional Court, with strategic impact litigation, the experiences have been very frustrating. They've been very technical and very cumbersome. A pattern has been established through analysis of cases that have gone through these superior courts, where often the judiciary has noted to have been taking what's called doctrine of avoidance, where a case is not litigated or is not adjudicated fully on its merits, but rather it's dismissed on technical issues. Our courts have been very fastidious about technical procedures, and this has really given fatigue to lawyers in as far as strategic impact litigation is concerned. And as such, in Zimbabwe, our jurisprudence, post-2013 constitution, in as far as public interest litigation is concerned, strategic impact litigation is concerned, has not been fully developed. Hence, we have relied largely on South African jurisdiction in as far as economic, social, cultural rights litigation is concerned. As WILSA Zimbabwe, we are a law-based organization, and as such, we do our interventions through challenging laws, through policy reform, and through taking up strategic impact litigation. And through the support of Afya, last year, we took up a case, and the background is that a minor got impregnated out of, she was not married, she didn't have the capacity to enter into a marriage, and as a result, she sought to have the pregnancy terminated, but now, it was either she was having the pregnancy terminated legally or illegal. So in terms of the act which governs termination of pregnancy, which is the Termination of Pregnancy Act, termination of pregnancy is generally allowed under two circumstances, that is the medical grounds, when it's certified that the continuation, it puts the lives at risk, or through the pregnancy could have been conceived through what they term unlawful intercourse. So the problem now is the interpretation that's given to unlawful intercourse. Unlawful intercourse in Zimbabwe is narrowly interpreted. It strictly means rape. You are raped by a stranger. It doesn't include rape in the cases where maybe husband and wife had sexual intercourse which is not consensual. Neither does it involve minors who do not have capacity to consent to sexual intercourse. Recently, Zimbabwe has criminalized marriage, child marriages. But now, through our client, we then mounted an application in the High Court. It was a constitutional challenge to say that Section 2 of the Termination of Pregnancy Act contravenes the Declaration of Rights within the Constitution. Why? Because we felt that the interpretation or the definition given within the Act on what is meant to be unlawful intercourse was very narrow and was also not protecting the rights of children as envisaged within the same Constitution. So we mounted our challenge in February 2023. We sued the Minister of Health because he is the administrator of the Termination of Pregnancy Act. We also co-sued the Attorney General. We also cited the Parliament of Zimbabwe because of their official responsibilities they had. The matter was heard on the 24th of February this year. So you can actually see the passage of time between the time that we filed the case, that is last year, and the time which it was heard, which was the 24th of February this year. Unfortunately, after the hearing, the judges have a right to reserve judgment, which is what happened in our case. We haven't received our judgment. The judgment has been reserved. In terms of the law in Zimbabwe, you can expect a case to be finalized between 90 to 180 days, but the law does not really provide for sanctions against failure to provide a judgment within that period. So to date, we haven't received our judgment in as far as the case that we filed. We believe that in terms of legislative reform, in terms of reviewing and challenging the law, this was a good case. Why? Because it spoke to repealing a very archaic piece of legislation. This is a 1977 piece of legislation. It was enacted even before I was born, and some of its contents are no longer applicable to a modern society, and we feel that the application was timely put before the courts. However, through that application, we have noted consistent challenges, which challenges often then would speak to the limitation of the impact that we are seeking through strategic impact litigation. For instance, in Zimbabwe, we often use the same lawyers. For instance, there are not too many lawyers who are keen to be taking up on strategic impact litigation for a number of reasons. Among other, the time, it's quite prolonged, it's very expensive, and the judges, the courts themselves are not very welcoming. The attitude, strategic impact litigation has been very much politicized. So lawyers are not keen to take them. Also, the rules around admission of friends of courts are very restrictive. For one to be admitted as an amicus, it's quite onerous. The burden you have is quite on the higher degree, and the discretion is at the court to admit or to then define what they term what is within the context of justice of the case. We also noted that capacity amongst lawyers in as far as strategic impact litigation is concerned is very low. In as much as the Constitution was enacted in 2013, we still have a very much undeveloped jurisdiction for a number of reasons. There aren't many cases that are litigated in as far as reproductive justice is concerned. Lawyers are not keen to identify strategic impact cases. And also, the judiciary do produce judgments without reasons. In Zimbabwe, we call them ex-tempo judgments. They will say reasons will follow. And with that, we don't have established precedents. And then lastly,
could that be the reason why we rely on South Africa?
Okay, and then the other last issue is, as a lawyer, you cannot, maybe getting back to the problem we're facing as WILSA, we have had the case heard in February 2024, we have not received our judgment. Outside the court, there is nothing more that you can do to compel the judge to deliver a judgment. You can only politely remind the registrar, who in turn cannot compel the judge to deliver a judgment. So our judgment has been reserved for too long. And some of the cases have died natural deaths, just without any judgment being delivered. So these are some of the practical challenges we are facing in as far as strategic impact litigation is concerned in Zimbabwe.
Thank you so much. Yesterday we learned that in one of the countries in Latin America, they mobilize women to get onto the streets. Solomon has also just indicated that at one moment I was on the streets. I was on the street for judgment because the courts were not being proactive to give us a judgment. Here they will say that we shall give you judgment on notice. They don't say reserve. And one of the things that maybe we learn is that we opted to take away the lawyers who are litigating the case because of the issues of discussing matters in court, to have people like me who were not practicing at that time and opt to demonstrate on the streets of Kampala. And for the very first time in Uganda, the judiciary apologized to civil society. And it's very easy. When you're speaking about issues that are known to everyone, it becomes really easy, and we really feel you. But there are also lessons, since we are here to learn. We had a judge here that passed on, the late Honorable Justice Kenneth Kakuru. In such engagements, he would always tell us that, you see, the judges wait for you to come to them. And he used to tell us that lay a brick. Think about it like you're building a house, and lay a brick every day so that the judges are able to move. Maybe it's time for us to lay a brick, to indicate that the more that judges take to give the judgment, there's an implication because this is a minor who is pregnant. You expect that when the judges are active, perhaps an abortion can actually be taken on. So maybe we need to think about the advocacy bit of it that comes with the litigation to take forward ourselves. But thank you so much for sharing that. I think it really brings us into conversations in Malawi. But also I love the fact that you're already noticing that you can pick lessons from South Africa. I don't know if other people have heard that, but I heard that you actually keep referring to jurisprudence in South Africa, and that becomes quite important. So let's get to Malawi, and we hear from Michael. I know that you also filed a case on reproductive justice last year. So we really want to understand what enabled you to do that filing, and how you're dealing with opposition or people with divergent views when it comes to reproductive justice. Over to you, Michael.
Yeah, thank you very much, moderator. Good afternoon. Yeah, so let me begin by providing background so that you understand where we're coming from, but also the challenges that we are facing and the challenges that we want to address. So Malawi, just like Uganda, I guess, Zimbabwe, the law strictly restricts abortion. So abortion is only allowed to preserve the life of the mother. Okay. In Malawi, abortion is only allowed to preserve the life of the mother. However, there has not been clarity on what preserving life entails. So as a result, many instances where continued pregnancy results in serious physical, mental, or psychosocial harm to the mother have not been clearly covered by the law. And you also appreciate the fact that in our country, in Malawi, we record high numbers of cases of rape and also defilement. Hardly a day goes by without reading in the newspaper that a girl somewhere has been defiled or a woman has been raped. Some of the girls actually fall pregnant as a result of the rape or the defilement, but they are unable to obtain a safe abortion. The other challenge is that existing clinical guidelines have not provided clarity on what constitutes danger of life during pregnancy. So as a result, healthcare providers in Malawi often find themselves in a legal dilemma. When faced with a girl who has become pregnant as a result of sexual violence, and she's seeking safe termination of her pregnancy, many health workers are reluctant or are not sure whether by providing termination they'll be violating the law or not. So considering those challenges, my organization, the Center for Human Rights and Rehabilitation, with support from Afya and Haki, and in collaboration with like-minded organizations like Nyala Institute, we have taken up strategic litigation in an effort to move the judges to provide the clarity on this issue, but also to provide an authoritative interpretation of the current law in Malawi. Let me say that there have been previous attempts to litigate access to abortion. There have been a number of attempts. In 2017, for example, ULSA and the Nyala Institute filed a case before the High Court, but unfortunately, the case did not take off due to some challenges. A second attempt was made in June 2021. This case was dismissed on technicality. However, the judge in his ruling made some clarifications regarding the provisions in the Penal Code, which are used to prohibit abortion. So, for example, the judge said that even though sections 149 to 151 of the Penal Code prohibit induced abortion, Section 243 permits abortion when a woman's life or girl's life or health is at risk. That's what the judge said, but as I said, this case was dismissed on technicality, and I will explain later what happened. And most importantly, the court also recognized the importance of safeguarding both mental and physical health as integral to preserving the life of the mother. In September 2023, CHR, in partnership with the Nyale Institute, with the support from Afya and Haki, we filed a case before the High Court. The case is still in progress, and I'll talk more about that later on. Our current strategy is we're trying to build on the previous attempts at litigation, drawing lessons from the failed cases, and at the same time trying to do things differently. In the process, we have noted a number of challenges, and I would like to just highlight a few of the challenges that we have faced. The first challenge is the issue of experience or training. So the first case that was brought in 2017 by our colleagues failed mostly because we didn't have experience in litigating issues of this nature. And that's why the case failed. A girl had been defiled, and she was made pregnant, and she wanted to ask the court to review the decision of the public health officer who had denied her access to safe abortion. But as I said, that case failed to take off. It was failed by the team that the case was new and there was no experience. Basically, the team didn't know how to go about it. And the team had also not been trained, prior to initiating the case. So it failed that way. The other challenge that we had faced was the lack of support from other organizations in the civil society. So the case was actually met with a lot of skepticism. People didn't really believe that such a case would make it before the courts. And there was also fear that maybe this case, if pursued, would undermine the advocacy on the termination of pregnancy bill. So there's a bill currently in Malawi, which has been sitting for over a decade, which seeks to expand the grounds for access to abortion from just saving a mother's life to also include issues like if the pregnancy is as a result of sexual assault, or if it's also a result of incest and other issues. So there was a feeling among civil society that maybe pursuing this case would somehow undermine the advocacy for the termination of pregnancy. So as a result, there was no adequate support from other players on this case. The other challenge that we had faced was finding evidence. So in the 2021 case, this is actually the judicial review cause 3 of 2021. In this case, a married man had defiled a 15-year-old girl, and she became pregnant. The girl, with support from her parents, requested termination of the pregnancy at the local one-stop center, but she was denied. The girl and her parents expressed interest to seek a judicial review of the decision to deny access to legal abortion. A legal team was put together to fight the judicial review, and learning from previous experience, a training workshop was organized for lawyers, and after that training, a case was filed. Unfortunately, the court refused to grant permission for the judicial review. The main reason was that the girl could not provide evidence that she had sought the termination of her pregnancy, and that the health provider had refused. So there was no written evidence anywhere. Therefore, the court could not review the provider's decision, because technically there was no evidence of a decision to review. The other challenge was finding potential clients. So in Malawi, litigation is still a new thing. People do not feel confident to face the courts, especially on issues to do with the sexual and reproductive health rights. And that has posed a challenge in pursuing litigation of this nature. There's a lot of skepticism. People don't really believe that the courts could be effective in terms of providing access to abortion. So, learning from the previous attempts, and also learning from the experiences that we have had, the lessons that we have learned, the challenges. In 2022, in September, our organization partnered with the Nyala Institute to pursue another case. This was a case of a girl who had been made pregnant after she was raped in her community. Her parents discovered she was pregnant after a certain NGO conducted a voluntary HIV testing campaign, and it was during that campaign that a pregnancy testing was also done. Her parents sought termination of the pregnancy at the one-stop center. So when the parents discovered that the girl was pregnant, they sought termination at the local one-stop center. But the clinician there refused to give her access to the termination. So learning from previous experiences, we first of all made sure that the issue of evidence was addressed. So we made sure that there was written evidence that could be presented before the court. So what we did was that we engaged the clinician, and fortunately he was very cooperative. He provided the evidence indicating that the girl had come to request for termination of her pregnancy. And this is what we had used to facilitate the girl's access to the courts. And also learning from previous experiences where our legal team was not properly trained, we conducted a training where we provided some training on how to conduct strategic litigation for our lawyers. We also engaged other civil society organizations, learning from the experience where previously civil society actors were reluctant to support us. We brought the case before them, we explained the merits, and fortunately, civil society organizations, most of them came on board. We also engaged the media, realizing that the issues of this nature sometimes, do get blown out of proportion, especially by our friends in the faith community. There have been instances where the faith community have mobilized, against in attempts to legalize abortion, and to avoid a backlash, we engage the media, building their capacity on how they can, effectively present this issue before the nation to avoid polarizing the issue. So after we had done all that, after we had done the trainings, engaged civil society, but also engaged the media, we filed the case on 27 September 2023. The summons were served, and all the defendants, that is the Minister of Justice, the Minister of Health, the hospital director, and again the clinician made their written responses. So the case is still on. The update that I can provide right now is that the case is still ongoing. Submissions have been made, resources have been provided, and most importantly, we have avoided the possibility of mediation, because we didn't want this case to go through mediation. We wanted the case to go, to full trial. And the waiver, the mediation waiver has been granted, and we are very happy about that. The order was actually given to us some 2 or 3 weeks ago. This means that the case can now proceed to trial.
Great, thank you. So we learned several things here. I want to have a feeling that the team in Malawi is already learning from the past to see how do we make better. And I think that communicates to the building of the house, one brick at a time. We hit ourselves, we stood up high and said, here we are, and we are moving. I love the bits that we are already learning from others, and perhaps such convenings bring us together to even learn more to see what we can actually do. I think one of the things that we may want to think about is security for this lady, for this girl, especially that the case is already out there. her being protected. Sometimes people run away from the court to even now attack the witnesses that we have, yeah? So you may want to think about that. So we've spoken about evidence, and I want to pick out the evidence from each of us. To now move to Dr. Peter. Dr. Peter, we have noted that in Kenya, you have provided a lot of scientific evidence in cases related to reproductive justice. And we wanted to hear your experience and perhaps bench on the fact, if possible, whether part of the successes of these cases relies on the fact that you're happy to always provide this scientific evidence before the courts. Can we really hear from you on what your experience has been? Also learning from the fact that in Malawi they struggled with the evidence, and we know that you can't go to court with words, you actually go to court with evidence. What has been your experience, Dr. Peter? Thank you.
Thank you for this opportunity, and thank you for inviting me to this panel. As I said before, my background, I'm a medical practitioner, obstetrics gynecology in Kenya, and I'm going to quote one case or two cases where I've been called to provide as an expert witness. One of the case was a 17-year-old, that was in 2019, who had presented to a healthcare provider with having had a spontaneous abortion. We call it PAK case, PAK case. So when she presented to this provider with incomplete miscarriage, she was offered post-abortal care. Post-abortal care is allowed in Kenya in any facility, even in mission-led facilities. You are not questioned, you're supposed to be managed for a complication. So after this, 2 days later, the police raided the clinic, arrested the provider, arrested the girl, and took away the medical records and those instruments that were used to provide post-abortal care. So the girl was accused of procuring abortion, and the provider for providing the abortion care. So we are called in to provide witness because 2 days later, the girl was taken to a public health facility and forced to undergo a medical examination. So when we are called in to provide evidence. And what we told the court is that the instrument used to provide post-abortal care are the same instruments we used to provide other gynecological services, including post-abortal care. So you cannot accuse this provider of using these instruments for providing these services, yet this instrument can be used for other services. You don't have evidence to say that this is what was used to provide the abortion service. The other thing is the right to health. Nobody can force somebody to be examined by force. And that is what the police did. They took this girl by force to a public facility, and she was forced to undergo a medical examination, which was a violation of her rights. Even the medicine we used to procure safe abortion, we can use them for other purposes in healthcare. This famous drug we call misoprostol. We also use it when somebody comes, they are in labor pains, but those labor pains are not strong enough. We give them those medicines to increase what you call contractions or labor pains. We also use the same medicine to prevent women who have delivered and they are bleeding a lot. So you cannot use that as an evidence to prove that this medical practitioner used the medicine to procure an abortion. We are happy because our evidence as medical expert was quoted in a judgment and the case was dismissed. And the case was not just dismissed, but the parliament was given instructions because we have a new constitution 2010 and it has a provision of services, safe abortion services, under various circumstances, 4 of them. And the parliament was instructed to actualize this 26 form where abortion is allowed when the health and the life of the mother is in danger, emergency situations. So the parliament was instructed to enact this so that
the women can benefit. So that was one case. We've also had a case where a woman went from facility to facility seeking safe services, but this was denied because the standard guidelines we had developed had been withdrawn. So the judgment was that this should be reinforced, and I'm happy that was part of the development of those standard guidelines. We are also involved as medical experts when we are making this progressive constitution in 2010. We had very strong opposition from the church, and actually just the second final draft wanted to stop at abortion is not permitted, life begins at conception. That is how they wanted it. But as medical experts, we came in and told the makers of the constitution that if we leave it at that, even a woman who comes with an ectopic pregnancy, that is a pregnancy that develops outside the uterus, it's supposed to be a medical emergency. But if we leave it that life begins at conception, abortion is not permitted. Even as a health provider, you cannot provide these services, which is an emergency, and we're going to lose so many women. Luckily, one of the senior people, the then Minister of Justice, had actually had a sister who had an ectopic pregnancy 1 week before. And that is why we managed to get this progressive provision in our constitution. So what can I say? As medical experts, we come in to provide first-hand experience because these complications come to us. On Tuesday before I came, I had a 16-year-old girl. We took her to theater, complication of unsafe abortion. The uterus was damaged. We had to remove the uterus. She had her intestines damaged. So after that, we took her to ICU with tubes everywhere. Tubes to remove her urine, tubes to remove her infection, tubes to remove the stool from the tummy. So that's the kind of things we bring in because we are the one who experience these complications. So we bring you first-hand experience when you give witness, okay? And one of the best practices I've learned is that, and I plead to the lawyers in the room, when you're developing these cases, please bring the doctors early enough in the development of the case so that they are part of this. Sometimes you get a call, can you come and give evidence next week? You have no time to prepare, you don't know how the case has been, but I'm happy that in our country, we have good working relationship with the legal support network and the medical support network. We come together, and even for these cases, we are able to be brought on time and develop the cases together so that by the time it comes for hearing, you have a lot of insight about the case. Thank you very much.
Wow, thank you so much. So I'll pose the most hardest question to you. So at one moment, we've been in court, and the health service provider has been put on the podium like this and asked, were you paid to come and give this evidence? Have you interfaced with such a question in court? Lawyers are funny. That question was asked in court, and the person was coming to give evidence on the structure of a woman and how one delivers and why it's important to pay attention on maternal deaths. And this question was posed to an expert. I'm wondering if you've interfaced with such questions and how you've dealt with them.
We get very difficult questions. What is your interest in this case? Are you a father? Why are you supporting abortion? Do you have daughters? Do you have sons? There's one case, this was a deferment case. And then I'm the one who had treated this young girl from complications of the deferment. And then the lawyer asked me, doctor, were you there? Then I innocently said, no, I was not. I thought that was the end of the question. So doctor, did you witness the erect penis penetrating the vagina? And I'm happy the judge came to my defense. We get very difficult questions to degrade you and even discourage you from being a witness. But we soldier on as advocates, and I'm happy that I'm one of the beneficiaries of the reproductive justice advocacy caused by Haki, and it has given me that strength, and I'm happy that I'll continue being a witness for the benefit of our women and girls.
Thank you so much. Have we clapped for Haki, really? Let's clap for Haki. It's interesting. We've always had questions of where the law meets practice, medical practice. And I think for me, this is the real intersectionality that we keep asking for, that away from being in the labs, how do we even come and meet the legal practitioners to see the real things? And I'm glad that Haki is making this happen. So we have had conversations around progressive conversations in South Africa. And we know that it's one of that country that has a law that is very progressive. We all admire you. And we feel like if it's litigation, it's an almost automatic thing to just go through because the law is very progressive. I think it's the choice of termination of pregnancy law that you have in South Africa that we feel like, okay, they have more ahead. But the question that we want to ask today is whether there has been the practice speaks to the law. What has been your experience, my people? Thank you.
Thank you. So yes, South Africa does have quite progressive laws regarding reproductive rights.
Do you want to speak from the microphone?
All right, sorry. So it's enshrined in our constitution under section 27, which is where the name of my organization comes from, which says that everyone has a right to access to healthcare. But what the drafters of our constitution did very well, and I like to think that they were feminist in that they added including reproductive rights. You know, they could have added anything else, but they made sure to write in that right that it includes reproductive rights. So that read together with the section on bodily autonomy, which also speaks to autonomy in respect of reproductive rights, gives us our then right to termination of pregnancy. From that, our legislature crafted our Choice on Termination of Pregnancy Act, which allows abortion on demand. It allows abortion on demand for up to the first trimester, so up to 12 weeks. And then from the 13th week to the 20th week, you can have your second trimester abortion, but it's limited to 5 grounds. And these grounds will become important given the case study that I want to speak about. The first of the grounds is if the woman's life is in danger, then she should be allowed a second trimester abortion. If the fetus will be born deformed, then the woman should be allowed an abortion. If the continuation of the pregnancy will negatively affect the woman's mental health, then she should be allowed an abortion. And then if the pregnancy resulted from rape or incest, the woman is allowed an abortion. And then my favorite ground is the socioeconomic ground. So if the continuation of the pregnancy will negatively affect the woman's socioeconomic status, then she should be allowed an abortion. And this is the ground that I rely on quite a bit in this type of litigation. Just to give you a statistic of how well this right is doing in South Africa, the 2029 statistics from our National Department of Health stated that 50% of the women who get abortions get them in the backstreet abortion or illegal abortion sector. And that is because they don't know that they have the right to an abortion. The illegal abortion sector in South Africa is so rife that women actually think that an abortion is illegal, right? It's advertised in this secretive way because it's illegal. And that also goes to show how much or how little the government has done to speak to this right, to let women know about this right, to educate women about the rights that they have. It also goes towards resources that have been allocated towards the realization of this right, which are limited. That is something else that we face as a problem, is the resource allocation towards this right. Within our constitution, as progressive as it is, the right is limited to available resources, and therefore if the government doesn't provide the resources, then the right is null and actually quite silent. So we hadn't had any litigation around this right at all until a case that we brought as Section 27 last year that involved a minor who approached our officers. She came in and she was in her school uniform, and when she approached our office, she was 20 weeks and 1 day pregnant. So she was 5 days shy of the cut-off period, being 20 weeks 6 days. And when I consulted with her initially, she told me that her parents had kicked her out of the house, and so effectively from that moment she was homeless. She had told me that her mother was the one who had looked up our organization and suggested to her that she should come and visit us. And then she also told me that she had actually gone to various health facilities looking for these services, and each time she had been turned away, which is why earlier I was speaking about the medical practitioners and medical staff, their role in providing for these services as being one that is crucial, and not allowing that stigma that we sometimes carry with us from our family backgrounds or our religious backgrounds to penetrate through their work. And so, the first time she approached the facility, she was told that she needs parental consent, which is something that's not actually it's not a thing in South Africa. The Choice and Termination of Pregnancy Act, Section 5 of the Act, actually says only the consent of the woman is what is required. And if you are a minor, you can consult with a family member or a friend, but the abortion should not be denied on the grounds that you will not consult with anyone else. And so that was the first time she was denied, and not knowing her rights, she then went away. The second facility she went to, she was told that the fetus was breached or was in a position that she couldn't get the abortion. At that point she was under 12 weeks, and from the medical evidence that we got in our case, the specialist that provided evidence for us demonstrated that could not possibly be the case, because she was the pregnancy was still so new. And this is also one example of how those who oppose abortion can use medical knowledge to abuse their position, to deny women these essential services, even in a country where it is legal. And so, not knowing her rights, not knowing anything, in terms of medical knowledge, she then went away again. And the third time she approached a facility, she was told that she was too far along for the procedure. And so she came to us as a matter of last resort. So we immediately had her, because she's a minor, we immediately had her psychologically evaluated so that we can be able to take instruction from her. Our act is called the Choice on Termination of Pregnancy, and therefore it had to be her choice. From what she had told us in consultation, it seemed as though she was being coerced by her parents, and so we just wanted to be clear on the ground that she was the one who was requesting our representation and the abortion. And following that, we then had her examined by a gynecologist who provided us with a report stating that at that point, this was the Thursday, at that point she was 20 weeks 2 days when she approached the gynecologist. And then on the Friday, we filed our court papers to ask for an urgent court order and to be heard over that weekend, given that she was going to run out of time by the Monday. We were able to be heard by a judge on the Saturday morning. Initially, the judge requested that we provide further evidence. So he had wanted evidence from a psychiatrist. Let me just go back one step. In our papers, we alleged, based on the ground of socioeconomic that the continuation of the pregnancy would affect her socioeconomic status negatively, we had based our application on that. And then the second ground was the ground of rape, given that she was a minor incapable of consent, and the person who had impregnated her was a 21-year-old man. Our application failed on the ground of rape, and I want to highlight this because we've had quite a bit of discussion this morning about the role of the judiciary in these kinds of cases. On the ground of rape, it failed because the judge in the matter did not view her being unable to consent legally as rape, because he said, in his judgment, he said statutory rape has an element of consent, and therefore it cannot be rape, and therefore she cannot get an abortion under that section. So after we had failed on that ground, we then proceeded on the ground of socioeconomic circumstance, and there he required further evidence. So the judge required us to then get the parents to consent and also to provide evidence on the socioeconomic status of this young girl and their socioeconomic status. This obviously being against the section in the Act that says parental consent is not required and that only the consent of the person requiring the abortion is the one that's necessary. And so even in court, even dealing with legislation and a constitution that allows women to get these services, we are still faced with judicial officers who are unwilling to accept, that a woman can be raped, or that a minor can seek these services without parental consent. And so we then went on urgently to seek a psychiatrist who could speak to her mental state, who could speak to her socioeconomic status. Luckily, her mother was willing to give evidence on their socioeconomic situation. And then we also got the social worker who had seen her initially and the gynecologist to confirm her gestational age. And then only at that point on the Sunday, the day before she became, or the day before she would become eligible for an abortion, we managed to secure a court order for her to be provided an abortion. And I think this... And I think this case just goes to demonstrate just the uphill battle that we all still have to face. That even once our respective constitutions and our respective laws are in place, this is a fight that we need to still continue to hold on. And we cannot lose the ground that we have. We have to constantly advocate for this position consistently. Otherwise, because we're faced with these kind of people who are in high-profile environments, who are judges in courts, and who maintain these patriarchal and misogynistic views of what a woman, of what it means or reproductive justice means for a woman.
I would clap for you again. How I wish. I honestly want to think that sometimes we need to get out of our comfort zones. Have you noticed that this team is working on a Saturday and a Sunday? And they're able to convince, I don't know how, because here Saturday and Sunday is weekends, therefore the courts will be closed. But how you're able to pull the judges to give you an order, even on a Sunday, is something that we need to pick on. So working out of our comfort and working harder to do what the team did is something that I'm picking out. There's also a lesson here. How do we get our instructions? Did you notice? When my people indicated that they had to do a psychological evaluation to get the instructions, I think for me that's a lesson that we pick. Why? Because you don't want this person to come tomorrow to say, by the time I came to you, I was not in a fit place to actually get the instruction. So we're here to learn, really. right? And I think these are lessons that we are picking on from that team. So thank you so much. We thought that in South Africa, it's okay for as long as it's still within that time and you have the law, you walk in and you get an abortion. But I feel like it's actually something different, meaning it's one thing to be on paper and another to actually get into the practice. So I really want to appreciate you, and can we kindly appreciate the panel. You have really done well. Thank you so much. So we are going to take off a few other 10 to 15 minutes to open up this conversation to you. And I'm not very certain where the microphone is, but we'll have 10 minutes here and then 5 minutes online, and then we'll close this conversation. If there are any areas that we feel we want to learn, or we have questions, or we want to get into a deeper conversation, the time is now for us to learn. No hand up here? Yes, Kenneth. Okay. Thank you so much. Please, if you're very sure, you can direct a question to any of the, who you want to respond to, and if or not, you can just ask anyone and then they'll respond to the same. Thank you.
Thank you, moderator. Our wonderful panel, thank you for the job well done. You're rich in content and you've ably shared the same. Allow me to add my voice to what Ms. Betty talked about, and also Dr. Swata, the President of Uganda Medical Association, particularly in respect to the force of law in relation to the work done by the doctors in the course of their work. I want to assure colleagues this evening that in the journey for attainment of the sexual health and reproductive rights, the doctors are not walking it alone, especially here in Uganda. We have the Legal Support Network, to which I'm a member, whose mandate is solely to provide a safe environment for the medical workers in the course of their work. Then beyond that, we are lucky to have SEHAD as an organization. In fact, SEHAD is the secretariat for the Legal Support Network, and has been the secretariat since 2014, if my memory serves me right. Yes, 10 years or so. Yes, so SEHAD, and then Afya and Haki has, through the LIRA program, has also given us space and the ability to offer legal support. We call it the rapid legal response, what Betty was talking about, to the doctors and health workers that get into trouble with the law. The challenge we get sometimes is that the SOS messages, if we all recall, usually don't come in time for the members of the Legal Support Network to intervene. But by and large, there is goodwill, there is effort by the legal practitioners who are spread across. And I want to assure Dr. Swata, as the president, that your members are not working alone, and we are there to continue giving support, as long as we are also supported by Haki and SEHAD. Thank you.
Thank you so much, Ken. We had another hand up on the same table. Thank you.
I have a question for Dr. Igogo. My name is Namulanda. I work with Kelin Kenya. And I wanted to get your commentary on the requirement of parental consent. The Section 16 of the Children Act of Kenya requires for parental consent when it comes to adolescents accessing sexual reproductive health services or information. From the perspective of a medical provider, what kind of challenge that this poses for medical providers in providing these services? For example, noting that even if we have the caveat under the section Article 26.4 of our Constitution, the Penal Code of Kenya still criminalizes provision of abortion. So when it comes to provision of these services to adolescents, what kind of challenge or restriction does this cause to medical providers in Kenya? Thank you.
There's another hand clap? Sorry, there's another hand up.
Thank you so much. Apologies for that technical glitch. I would like to appreciate the panel for sharing extensively. Thank you so much. I would like to add my voice to Betty and Council Kenneth in respect to the legal support network here in Uganda. So you notice that as Betty was sharing, she indicated the challenges that come with police. You know, the law, I don't know if I don't know if I should say they do not understand the laws surrounding abortion, because we have to continually, draw to keep drawing it out for them that PAC is legal while the self-abortion is illegal. So because they cannot draw that difference, even what is PAC, they have health workers arrested for it. So we have had to continually train them on the legal and policy environment relating to SRHR in Uganda, so that they come to an understanding that you need to look at the facts wholesomely and not the fact that there was an abortion, but you've not questioned whether it was PAC or it was procuring of an abortion. But also, under the legal support network, we use 3 approaches. We have the preventive approach, the advocacy approach, and reactionary. So the legal rapid response is the reactionary. When they are falling within the criminal justice system, we respond with rapid response. But also we have the preventive arm. The preventive arm is prevent them from falling within the criminal justice system. So this is where trainings are done, either for jealous actors, for health workers, to know what environment they're operating in, but also how do you safeguard yourself from falling within this criminal justice system. So in here, they are given the laws and policies. We've given them a lot of material that can help them understand the legal and policy environment, but also how best do you safeguard yourself if you were, to fall within the criminal justice system. And some of the things we've done there are compliance assessment visits. We visit their facilities to assess them legally. Do you meet the legal compliance test? Because when police can't catch you on abortion, they will say you don't pay tax. You don't pay NSS for your health workers. You don't have a tax, a tax ID. You don't pay the council fees for the area you operate. So we assess them to ensure they're operating legally, so that they close all loopholes that police could probably exploit when they come to, raid the facility and, carry records. Also teach them proper documentation. How do you document so that you don't fall within the criminal justice system? And also sometimes these compliance assessments, we move with health workers to do them so that they assess them medically to ensure they are fitting within the medical standards while we do the legal assessment. Because the legal support network is made up of health workers, but also lawyers, because we know we can't do this work without the health workers. And also the advocacy approach is where we do advocacy for progressive legal and policy environment. So we engage at different levels, national level, to ensure that we move to a place where the legal and policy environment favors the health workers. Thank you.
Thank you so much, Ruth. We had 2 more hands. Let's get the hands and then get online.
Afternoon, everyone. My name is Tendaishe from Zimbabwe, and I would like to thank the panelists for such insightful experiences from your context. And I just wanted to acknowledge sort of the diversity amongst the different experiences, where things are working in some contexts and the system is not working in others. So for example, South Africa, they can file a case on Friday and get a judgment on Sunday. And then we have Zimbabwe that can, that takes more than a year to be heard, but maybe even more to get a judgment. And I really want to settle on the cases in Zimbabwe and Malawi and acknowledge the skepticism amongst, the lawyers, amongst the public in general, with the judicial system. And just to probe further on what can be done to restore the trust in the system, because we need that trust to mobilize, to ask for a judgment. I know there was a suggestion to maybe take things to the street, but that can only happen if people trust that the system will hear them and will work. So my question is, what can be done? What is the role of the media? What is the role of other advocates to sort of support the litigation that has been happening in the context of Malawi and Zimbabwe? Thank you.
All right, thank you so much. Do we then call that legal activism? Because the lawyers will tell us our job is to analyze the pleadings, go to court and litigate. What happens after that is none of our business. While Ruth is saying for us, we also take the other perspective to actually say, this is what the public is, should be doing, because what you're speaking about are things that impact on everyone. So maybe we need to think about that as well. So there are two more hands. Let's get the two more hands as we get to the panel to respond to the two questions that have come through. I think the others are really additions. Thank you.
Thank you, and good afternoon. My name is Giovanna, the Executive Director of Women's Link. And first of all, I want to also to join our colleagues here and appreciate the panel. Like we can see through your presentations, your pain, your joy through every case. And I want to thank you for that and for sharing that with all of us today. My question, it's very connected to that. And I'm wondering, what kind of mechanisms have you put in place for your own well-being and the well-being and collective care of the teams that have been involved in the case management? And how do you sustain that in your organizations? So, because we are all humans, right? And our emotions are also connected to all of the struggles of the women, girls, and gender diverse people we represent. So that would be my question.
Thank you. One last person. There's a hand in the corner. Nimrod has a hand up.
Thank you so much, distinguished panelists. Mine is a question to all of you and maybe even to you, Noor. In terms of, because I know you sued Pastor Martin Sempa, who is one of our most vocal anti-rights actors in the Equal Opportunities Commission. In terms of taking this fight directly to the anti-rights actors, what do we need to do so that we make it financially costly, but also in terms of their reputation, we put them on the spot and shed light on what they are doing? How do we go about that? Either by suing them directly, whether it's for negligence or discrimination, and just taking the fight directly to them in courts.
Okay, thank you so much. So I'll get back to the panelists. The questions are posed to you. Please just pick up what has been posed to you and then respond to that. And if you don't have a question, you can give your parting shot. But if you want to respond to Nimrod's question, maybe we think together. Dr. Peter, I'll start with you. Thank you.
Thank you. I'll respond to the comments on the support of the healthcare providers. I'm happy that in Uganda, the healthcare providers are not alone. They are supported by Legal Support Network. We are doing the same in our country, Kenya, and that is very encouraging, including the compliance visits. We also conduct them to make sure that we limit those avenues where the police can raid the clinics and arrest the providers. The issue of consent, it's very controversial because it's introduced by those anti-rights groups where there's need for parental consent before you provide reproductive health services to the adolescents. But we are sensitizing our providers, including senior doctors, that who has come to you in the clinic is not the parent. It is that adolescent. And she has come to you because she's sexually active. What is the implication if I deny this young girl family planning services? The next time she's going to have unwanted pregnancy, unintended. The next thing, unsafe abortion. The next thing, complications. So we are urging them and sensitizing them on the need to provide a woman or the patient-centered care. The person who has come to you, you put her interests first before anything else. Our Constitution, Article 43,
make and ensure that every woman has the right to health, the highest standards, including reproductive health. And if we quote that, and we know the Constitution is supreme, that is what we are quoting to provide reproductive health services to the adolescents. Then there's the issue of the mature minor. They can put down that you have understood what you have explained to them, and then you can provide services to them. Remember, as a country, even as a region, we also have ratified international instruments, and there are also WHO guidelines. So nobody can take you to account just based on a policy from the Ministry of Health. But I'm happy that Kellen, I think, has taken up this case, and is one of those avenues for litigation. But in the meantime, we are taking as a barrier, but taking it positively and exploring avenues in which we can provide reproductive health services to the adolescents and in the best possible environment in what we are calling women-centered care. So this might not come back to me, so let me give my parting shot. We are looking at the avenues for litigation, and as health providers, we are experiencing a lot of mistreatments for women who are pregnant, during delivery, and after, what we call obstetric violence. It's one of those avenues for litigation, and I'm actually doing my PhD on obstetric violence, and I'm happy that some of my colleagues have taken it as an area of litigation. Thank you very much.
So much. Please proceed, Mapipa. We said you respond to the question that has been posed to you. If you don't have a question, you give your parting shot.
I'm going to respond to two questions. The one raised about what mechanisms we use for our own mental health. In my organization specifically, we have a partnership with another organization that provides mental health services. It's free to all staff. Sometimes we do a group session, and we've had many cases where our clients have nearly died due to medical neglect during abortion provision. One recent case, we had a 14-year-old who nearly died twice. First because she bled out and nobody noticed. She was just given the medication and told when to administer it to herself in the facility, in the hospital. And then she bled out and nobody noticed, and she needed a blood transfusion. And we had to be there. We had to be there to ensure that the process was done and kind of oversee the medical staff, because we know from experience that there's neglect. And then secondly, then she nearly died because nobody thought to check that the products of conception had exited the womb, all of them. And so she had sepsis and she needed IV antibiotics and all of that. And so that really triggered some of the members in the team. And we had to have this session and sit and talk about it. We've shed tears, we've taken time off. So we really do try, because we understand that we are all individuals who are living individual lives and who have individual experiences. Some might have children and daughters and whatnot that they might relate this experience to. And so we try to take care of our mental health too. It is important. And then the second is, how do we make sure that it costs those who oppose women's rights in this way, financially or in terms of like their public image? So we've found it difficult to use the media in these kind of cases, particularly because of the stigma that surrounds abortion. So it's quite difficult to rely on social pressure, as we do in most of our health justice cases when it comes to things like abortion, because it's a hot button topic. So a lot of the time, it is really just us as an organization, and maybe a few other organizations in the sector who would put pressure on the individuals concerned. However, as an organization, we've recently been able to establish a precedent in South Africa on another health rights case, but that relates to mental health, where in that case we have managed to get the individuals responsible for making the decision that led to the death of people to be tried for culpable homicide. And so we're hoping to use that decision or that judgment in other cases where there is, for example, medical negligence, or where there is negligence from an administrator or an executive who's making a decision at the Department of Health on whether or not a woman should get an abortion or not. Thank you.
So much, Vanessa.
Thank you. I will speak to the issues around skepticism in as far as strategic impact litigation is concerned, and probably strategies to address low confidence in judiciary system. I think in Zimbabwe, what we ought to do and what we have been contemplating as WILSA is to create a database of lawyers who are equipped in taking up cases around strategic impact litigation. I will share with you a very funny story, but it kind of builds a context within which lawyers litigate strategic impact cases. So in my former employment, I was head of litigation for an NGO. So I instructed an advocate, he's not an advocate rather, I instructed another lawyer to do a particular case for the organization. And then we went to court. So as he stood up to address himself, the judge simply said, "Oh, it's you again. How can we help each other?" So on the roll of cases, he had appeared 3-4 times before. So already it creates undefined biases, both against the lawyer as well as indirectly against the client. So it's very important to build a very deliberate strategic litigation strategy. What is it that you want to achieve? How do you identify a lawyer? How do you remove those biases, which in turn may affect a good case? I think it's also important to partner with the media. In Zimbabwe, as lawyers, we are not allowed by professional duty and responsibility to comment on our cases as they are still being adjudicated before courts. So out of frustrations, lawyers who often undertake strategic impact litigation would resort to go on social media, talk about their cases and what they're doing, the frustrations they are facing. And then the Chief Justice took to it and called upon the Law Society to discipline those lawyers. It becomes an act of misconduct. So you then need to step out and see who's going to be my friend, who's going to be my enemy, who's going to be enable this case to success. So those strategies may then slowly build up and help. And then lastly, my part short would be, in our respective jurisdiction, probably we need to have a conversation around what National Human Rights Institute can do in as far as reproductive justice is concerned. In my own jurisdiction, which is Zimbabwe, I've noted that we do have what we call Zimbabwe Human Rights Commission, which is a commission established by the Constitution. We also have the Gender Commission, a commission established by the Constitution. Their interpretation of human rights, it's very fixated around civil and political human rights. So because we have had the state being a perpetrator of human rights violations, you're looking at who has been beaten by police, you're looking at who has been beaten by members of the National Army. We are not looking at sexual reproductive health rights violations. So I think that kind of expansion and that kind of deliberate conscientization of these key institutions probably can also come into and build up the momentum. Thank you.
Thank you so much. Let's go to Micah.
Yes, so I would also want to respond to the question that was raised by Tendaishe on addressing skepticism. So what we are doing in Malawi is to celebrate the little wins, the little gains that we are making in the process. We have realized that skepticism is coming because people don't see progress. They don't see the results. And so to address that, we have impact on activities also to highlight the progress that we're making. And to that effect, in June of this year, CHRR, which is my organization, in partnership with the Nyale Institute, and of course with support from Afya and Haki, we organized an activity to celebrate the judgment that was made in 2021. Which even though the judgment, I mean, the case was dismissed, but the judge made some very progressive pronouncements regarding the exceptions to restriction on abortion. So it's the first time we did it, and the response was very, overwhelming. What we did was that we invited some media organizations, some media houses to come and cover the event. We produced a statement where we highlighted why we thought this was a win, for the movement. So that is one of the strategies that we're using, and in future I want to use it more and more so that people can appreciate the progress that we are making along the way. The other thing is training the media, but because we have noted also that in Malawi, just like in the other countries, the media is interested more in negative stories. If a judgment hasn't gone in our way, then a headline will come. CSOs dealt a blow. We want to train the media so that they can also frame these issues in a more positive light. We always say that there's a positive lining, in every crowd. And it's important that the media should also be able to identify the positives that are in the judgments that may be seen as negative.
Thank you, and let's hear from Betty.
I think mine basically will answer Giovanna, the ED of Women's Link Worldwide, in terms of how do we sustain or maintain some of these gains, or how do we work, like sustain the work we do. I'll start by saying that all of us in this room, we are working towards contributing to advancement of reproductive justice. And at a certain time, we shall all retire and there will be another movement coming.
Yeah.
There is always the time that there are people who are before us, and here we are, and there will be that time where we shall sit and we would have trained other people to take on. So I'll say that at the national level, through Afya and Haki, under the Lila program, we have worked closely with SEHAD, closely with Haki, closely with the Springs Interest Litigation Hub and other organizations to be able to advance some of these. And through also the Legal Support Network, I've seen times where SEHAD doesn't have money, but lawyers are working through the Legal Support Network because they've been able to build the system in terms of building structures at the national level. And in terms of the community level, as Women with a Mission, we have trained SRHR change champions within the communities that we work with. We have trained SRHR change champions from the adolescent girls and young women. We have trained change champions from the LBQ and T movement. We have trained change champions from the sex worker community. That these are people who are trained to understand these issues. And even where we can't reach, they can be able to provide this legal rapid response in terms of maybe police representation, because they're trained as agents, but also provided with a little knowledge around the law on how to react on these cases. But also we have gone further to build or strengthen a grassroots rural movement in terms of bringing together an SRHR coalition in Eastern Uganda, where we are bringing different organizations in this movement, where we are trying to discuss and bring on board the issues and narratives around abortion, so that these are people who can be able to speak in these issues, and we are able to address our own narratives within the Eastern region. And in terms of my parting shots, I would say, yesterday I had the reflection, and because of time, I couldn't talk about it. But when the team was presenting from the Latin America, you would see that there has been a lot of victory around using litigation to advance reproductive justice. And there was that particular one country, I think it was Argentina, where they had almost like 21 cases. And here we are in Uganda, we are talking about the SEHAD case, the HIRAF case, the women pro bono. We only have 3 cases. And I would like to thank Afya and Haki, because one of the things we have, I think, been able to discuss is how do we conceptualize cases? How do we be able to work with courts? If advocacy has failed to help us advance, because advocacy, you move one step in front, then the next day you hear you one step behind. How do we work with courts in terms of litigation to be able to advance reproductive justice? And it is one of the things I think we should take from Latin America. Thank you.
Thank you so much. I think you meant to speak about not the cases that are few, but institutions that are few that are speaking about this. So I'll summarize this conversation, which are meant to really look at the state of reproductive justice practice in Africa, looking at cases from various countries, as have indicated. And I want to share experience of media fellowships. About 10 years ago, we had challenges with media. You would wake up every day and you have a title, a heading, abortionist doctor, either incarcerated or this or this or this. Yeah. And when you intervene, you actually you would find out that that's not the case. Sometimes, maybe somebody's got where they're providing post-abortion care. So we opted to have a media fellowship on an annual basis as a must. Every year, we have a fellowship for a week from across Uganda to just have conversations around these issues and understand, so that they have evidence-based reporting. And I want to think that it has made us proud that it is structured in such a way that we'll have the conversations, but also attached to experts, so that they have the expert conversations as they do the reportings. And I want to think that this is really paying off. I also want to think that the cases that have not been discussed here, because they're still in court, but one of the things that we see is that strategic litigation is not a thing that everybody might want to do. But think about the community that you're going to serve at the end of that day. The reason it is strategic in nature is because it's coming up to change a system. So think about the beneficiaries at the end of the day as we move forward. I think the main reason we're here is to learn from each other. I know that Women's Link Worldwide supports build capacities of institutions in having strategic litigation strategies. I notified to them that I've been in their offices in Bogota for 2 weeks to do a strategic litigation strategy for an abortion case in Uganda. And I want to think that it wasn't wasted time. So maybe one of the things we can do is to even think about, even if you don't go to Bogota or Latin America, but you can have online conversations. I think we picked a lot from COVID to see how we support each other. Again, one of the panelists indicated that the lawyers are not trained. We have all the resources here, and I think one of the reasons we get together is to even learn from each other. So maybe you want to sit down with a team of lawyers and you have sessions, maybe bi-weekly, to just understand, and you build that case by case strategy so that we see how we support each other. Sometimes we want to file cases, but maybe we want to take a step backward and listen in. This is what we have baked at SEHAD. We'll always say we want to file this case, but how about we discuss it with maybe IPAS? How about we discuss with Kalin? How about we discuss? So kind of tapping into the knowledge that we have already as a team might be important. And lastly, celebrating wins. When you spoke about celebrating wins, I quickly ran onto the agenda and noted that there is a networking dinner from 7 to 10 p.m. Maybe it's the time for us to celebrate these wins, and celebrate ourselves. We've worked so hard to even share the experiences that we have. So perhaps Haki will speak to us about this dinner, but we can utilize it to celebrate ourselves. Having said that, I am going to ask the team to stand up and stamp their foot for us as we take our seats. Why? They've been seated for a long time. We want to chase away the non-communicable diseases while at the same time appreciating ourselves. So we are not going to clap. We are going to stamp our feet as part of celebrating the team that has been here. Okay, if you can do both, the better. But we wanted to feel that feet stamping and appreciating the team. So thank you so much to the panel, and I want to hand over to you, Salome.
Thank you very much, panel 2, for having allowed us to land safely and put context. I'll just need a few minutes of your time. Can I have a few minutes of your time? Thank you, panel 2. For having allowed us to land safely, but also to contextualize some of the things that appear to be very high level to the reality of what happens. We're now coming to the end of the day. A lot has been discussed today, and some of the conversations have been around what is out there, what is the ideal, what is the reality, where are we at, what have we achieved, what is still remaining, what strategies work for us, but also how do we synergize as legal practitioners, how do we synergize as healthcare practitioners, how do we synergize as the judiciary, how do we synergize as advocates, but also how do we walk this journey with the people we claim to represent, on whose shoulders we stand tall. So, as we are trying to conclude, and before I give you the instructions for how we are going to dance to the revolution, they say, what's the point of the revolution if we cannot dance? I hope you've had a bit of testing. There's a band waiting for us. They're actually thinking we are late. We're going to dance tonight because what's the point of the revolution? But before we get into that, I'd like to take the opportunity to invite Honorable Justice Okalanyi to give us a few words for maximum 5 minutes, so that we end the day on a high note. You're welcome, Honorable Justice. No, you can just say hello to us. We can't allow you to go scot-free, because also more importantly, we are in your geographical scope. We are in Entebbe.
Cheeky. Very cheeky person. I love her dress. Beautiful, isn't it? I didn't want to say anything because I have really been confused this morning by many things that I have had. Disappointing things, positive things on reproductive justice. I had the Director General Haki saying, judges wait for everything. They are spoon-fed. They are bad guys. They can't do anything. And he knows that that is the truth. The law ties our hands. Before I joined the bench as a prosecutor, I was really a free bird in the air. And I would have said so much that you guys would now be tired of me. But as soon as I crossed over to the other side, I was told to behave like a judge and stop those prosecutorial tendencies that you have. I'm here to encourage you. I think that apart from learning the many things that I've learned from the various jurisdictions that are represented here, I have had positive things And I want to first of all commend Sehad. I don't know a Haki. Okay, I met them 2 or 3 years ago at the launch. But I do know Sehad and the great work that it has done. Someone said we have 2 or 3 cases. We have so many cases on reproductive justice, positive cases. Some cases that have been delivered by non-activist judges. The Nakaseke case by the current chairperson of the Judicial Service Commission. Would you expect that kind of decision that recognize the responsibility that local governments have to provide healthy environment services to women that go there for maternity services? So we are doing very well. I know there's a problem of implementation, but I want us to know that we are dealing with a very big problem. And in Africa, I had someone say, oh, we have a new constitution of 2010. That was the good doctor from Kenya. 14 years passed and that is still new. We still say, oh, we have this law, 2010 passed on female genital mutilation. It's a new law. Indeed. Even the practitioners still don't know what the law is. So things take a long time when they are still new in this continent. And my opinion, humble opinion, is that we don't get discouraged, even when the edicts that Judge Luswata was talking about, the judgments that we have in our hands that are positive are not yet implemented. You know that the whole implementation mechanism is a governance issue. It is. Oh, I forgot to tell you, I'm the chairperson of FIDA Uganda. And sometimes I speak like civil society. I'm still having problems, not speaking like a judge. But yes, so we are fighting a gender justice. It is not just reproductive justice. And gender is such a difficult thing. Even the judicial circles. You know, today as a member of the Women Judges Association of Uganda and of the International Association of Women Judges, you have achievements here and negatives on one side. Here you have numbers increasing, there you have the numbers are in the positions of foot soldier. You are not in policy. You are not in decision making. Should we say we end the fight? No. Aluta continua. But we can make use of, I heard it being said, did I record it? I mean, what haven't you guys done? Or we, you know? Maybe you are not monitoring government actions and tracking them, I don't know. But I had someone saying, oh, these days there are reports, I think the good doctor from the Medical Association here in Uganda, that there are some reporting and, what did he call it? Evaluation of every maternity death, you know? If that is happening everywhere in every health facility in Uganda, I think we are beginning to create data and to take the right steps. Engaging in advocacy and lobbying, yes. But I was asking myself, where is UN? Where's the UN? Where's the real Ministry of Health? The people who are in governance in the Ministry of Health. I've been to other functions by Haki or Sehad, and the Minister for Justice, for Health, has been invited and has been involved. That kind of collaboration should be there everywhere, every time. Of course, it has been said, involve judges and justices. There's a difference, incidentally, in Uganda. Justices are for the Supreme Court and the Court of Appeal. Judges are for the High Court. Building coalitions, that is it, with all of us, everybody involved, in one way or another. And some of us are more involved in certain aspects of reproductive health than in others. So when you talk of certain areas, we are seeing Greeks are the ones talking, because we have our area of specialization. What I don't see much about, empowering communities. I've heard someone saying, oh, we have our, what are those community paralegals? What equivalent of paralegals, but in the health area? But what about everybody in the community? When the major issue is values, customs, cultures. In this country, we have kicked polio out. I think we are about to kick malaria out. But the campaigns for polio, the campaigns for, against tuberculosis, against HIV, they were running on the radio, running every day. Everybody had. So I have not seen this. Forgive my ignorance if it's happening, and I'm very busy in my judgments. It's possible. So I think empowering communities is where the whole thing lies. For me, as a gender justice advocate, that is the area where I want someone to give me money. And in the judiciary, yes, we are engaged with communities. We are. As for judicial activists, there are very many. Batema, you know Batema, and many others. Some are more subtle, but they are activists. Some are crazy, like myself. I just had I'm actually relieved and celebrating as we are here. There's a conviction that happened the other day of Thomas Coelho. As a judge of the International Crimes Division, I was the pre-trial judge that confirmed 90 charges against Thomas Coelho. Half of those charges were brought under customary international law. Never before had any court in this country confirmed a charge that is not in a penal legislation. But I did. And I was criticized by academia more than the judiciary. What does she think? Who does she think she is? You know, does she want the people who committed the Mukura massacres to be also brought now under customary international law? Doesn't she know that there is a law, a Treaties Incorporation Act in this country, that this is a dualist jurisdiction? It's not a common law jurisdiction? That judge is mad, you know? And those things offended me initially, but now I've developed a thick skin. I don't really care. But there are many other judges who are activist judges who could do something for the sake of justice. I've said too much. Thank you for listening.
Thank you very much, Honorable Justice. We've enjoyed ourselves. We wanted you to go on. The good thing is that you're here with us, and we really value the honor you've given us to stay with us in this conversation. Now we've come to the end of day one, not the end of the Baraza. Remember, we said in the structure of the program, one session leads into another. In other words, we are appetizing ourselves for the next sessions. So, in the spirit of celebrating what we've achieved, but also getting to know each other better, we are going to break off now and prepare ourselves for the dinner. The dinner is going to be held at the poolside. The dinner program, we didn't belabor you with giving you a dinner program, but the people that are going to manage the program have it. But in summary, we expected to arrive at the dinner venue by 6 o'clock, because by 6 sharp, we are having opening remarks. Few remarks, each person has only 2 minutes, because we are supposed to start networking. Those of you who are vigilant enough, you can even arrive earlier than 6. So that you start enjoying yourself. There's going to be drinks on the house, there's going to be dinner, and there's going to be so much fun and excitement. We also have a live band, and for those of you who are on this part of the continent, we've brought the best live band in Uganda called Abeka Band. So go and put on your dancing shoes. For those of you who have all those exciting clothes that reflect your country or where you're coming from, please don them. Do not police yourself. Look good for yourself, feel good, and more importantly, enjoy yourselves. And lastly, at the dinner, we are going to recognize 2 awardees, 2 people from the judiciary who have stood the test of time and given positive, progressive, reproductive justice judgments. Please go and be part of the history and her story of knowing who these are and celebrate on their behalf. With that, I'd like to thank you all for the day. Enjoy yourselves, and let's see each other. And I officially now hand you over to the MC of the dinner, who is going to be taking charge. Come ready to dance, come ready to network, and come ready to be yourselves. Put your hair and everything down. Until tomorrow, see you in this room tomorrow. But for the dinner, let's meet at the dinner by 6 o'clock. See you then.